Item 39.
Petition is dismissed.
Obliged.
Litigation 3954 of 2025.
Petition is dismissed.
Litigation 887 of 2026.
Petition is dismissed. Yes.
With your lordship leave, my lord, item number 32, I am mentioning, I mean, from the other side. My lord, this was the part,
Appearing.
they are also present. My lord, this was the part-heard appeal which we were arguing on the last day.
Yes.
My lord, we have come today also from Kolkata. But I was humbly praying if your lordship allows, subject to your lordship's convenience, if we can come at 12 noon. As on the earlier date, lordship had allowed us. We hope the matter will be finished in in course of the day. If your lordship allows, we can come at 12 noon. This was that issue
Well, no, I
regarding
mean,
that
try-
transfer of shares
Yes.
and that part-heard matter, where Mr. Banerjee had made submissions.
We'll try.
We shall come at 12 noon. Great. Item number 32.
The item number 36, with the consent of the other parties, madam, I will take motion for adjournment for the today only, madam. 36.
The prayer of learned counsel for the petitioner. Place the matter again on. Give a date.
You go, May, madam.
6 May.
May I please, Your Lordship, I beg to mention item number 20, my lord, 20, my lord.
Hmm.
Can this matter taken on 38, my lord? April?
On the prayer of learned counsel. List again on 30th.
I beg to mention item number 26 from the daily list, madam. On behalf of Mr. D. Sutia, he's today not available. Lordship. May I pay for on list?
26.
26.
26 blank.
CD is available.
He's out of session today, Lordship, so I pay for on Monday, Lordship. Blank.
Deputy.
27.
Wrongly listed.
Developed.
Lordship CD is available.
Wrongly listed in the supplemental.
Lordship.
Hmm.
15 in 26 of.
If it is wrongly listed, then already item 26 matter is wrongly listed. List again on. Already fix a date then.
27.
Already CDB retained. Interim order passed earlier to continue. Huh? Oh, acha. Oh, here cause list to ase here likha. No, if it is, yes, it has been omitted from the main cause list, so we are not passing any order. It is wrongly listed. See the supplementary list, item number 26. It is omitted from the main list. There will be no order.
May I please, Lordship, I beg to mention item 119. I want to withdraw, Lordship. Charge has been filed. The petition will approach before the court.
Item number 19 on the prayer of learned counsel for the petitioner matter is dismissed as withdrawn.
It has been filed. Withdraw question.
Wait, please,
Your
Lordship.
Lordship, the item number 36 is mentioned, Your Lordship. Date is fixed on 6th, Your Lordship. Kindly matter, date me fixed on 7th, Your Lordship. Item 36. Oblige, Your Lordship.
Wait, please, Lordship. Lordship, item number 31, may can be adjourned for the day only, Lordship. And may can be fixed in the next week, any date, Lordship.
31, list
31.
again on.
5th of May, Lordship.
Yes.
Oblige.
May I please, Your Lordship, item number 33. My senior is out of station for his better treatment. Kindly pass over the matter after 2 weeks.
33.
Get after 2 weeks, give a date.
30.
Oblige. 21 May.
Lordship, I beg to mention item number 25. The leading English counsel today is not well. Can it be fixed after 1 week?
25 lordship CD is available.
CD.
arguments.
CD
Next week. Did you?
Your Lordship, there was,
Did it be retained?
there was an earlier interim order.
Hmm?
Interim may be continued.
Interim order passed earlier to continue.
7 weeks.
till next day.
7 weeks.
7.
May I please your lordship? I beg to mention an unlisted criminal appeal for listing on 30/04/2026. And the last posted is on 31/03/2026.
Mention for listing.
Huh.
Go to senior bench.
Put number 8. Put number 8.
May please, your lordship. Lordship, as regards item number 43, the TCR was called for, that has not been received, madam.
43.
43.
Not received.
Not received.
TCR is called for has not been received. Issue reminder list again on
4th of May, madam.
4th of May.
I'm deeply obliged.
On be item number 1.
May I please your lordship? This is the regular bail lordship. Petitioner is on jail since 24/02/2026 lordship. Today is 58 days lordship. In this matter lordship, have a look, the page number. The main FIR is a page number. Number 14 lordship, may I read lordship?
Yes.
With a reference to the subject cited above, I have the honor to report that today on 21/6/23 at around 4 AM, information was received from the reliable source that a mini truck bearing registration number so and so coming from Gauhati towards Nagaon side carrying some stolen cattle. Moreover, sources also reveal that some persons are escorting the said vehicle carrying cattle in the Tata Tiago or car bearing registration number so and so. Accordingly, I along with the staff put a NACA checking duty at meat supply NH15. After some time, the said vehicle coming from Tejpur side was signaled to stop at the NACA point, but the vehicle did not stop. After chasing the vehicle, it was able to stop at Ghoramari.
This has been charge sheeted.
Matter already charge sheeted. Then after lordship, he was in he get bail lordship on page number 14/8/23 lordship. Then after NBW was issued lordship 3/10/2024. Page number is
So he was arrested on strength of NBWA.
ship.
Forty-eight lordship. It was found that the conduct of the accused regarding his appearance before the court is not at all unsatisfactory by the court.
Lordship, we are already Lordship, have a look at the page number 44. We already filed a criminal petition for quashing the NBW lordship, and that at the para number 10 lordship, the next date 24/2/2026, on the basis of the warrant of arrest, NBW issue against him by the trial court from time to time, taking into consideration the interest of the expeditious trial. This court is of the view that the warrant of the arrest issue petitioner on 3/10 towards keep abeyance till 26. He appeared 24/2/26 before the land trial court and praying for bail, and that day he wasn't arrested because earlier he already approached before this honorable court lordship regarding the quashing of the NBW lordship. So right now he won
Which page?
page number 44 lordship. Para number 10 lordship.
to page 45, Lordship. Order dated 24/02/2026. He was found to be defaulted for 12 consecutive days. That's from 3/10/2024, Lordship.
Name of present accused is
Sergeant. He's 79.
Cattle Preservation Act.
Cattle 37411 or cattle preventive of cruelty and animal act. Cattle preservation.
It's the owner of the truck.
So there are other co-accused also. This is under Cattle Act.
And 379.
So the court has to first heard all of you like cattle come appear. Only then trial can proceed. Sorry, we are not allowing this. Heard learned counsel for the petitioner.
Lordship,
And-
then maybe TCR may be called Lordship.
What will that do?
Then after, because of he wants to appear each and every date.
No, he has appeared after this court
Already,
granted liberty.
Already today is 58 days Lordship, and previous already he granted one bail, and before this honorable court he approached the NBW, and this honorable court.
One will go out, another will come. Then he will, the one who has gone out, he will not come. Trial will be kept pending that way. Heard learned counsel for the petitioner, an additional PP.
Lordship, we will want to withdraw this matter, Lordship.
Right, very good. Learned counsel for the petitioner. Praise for withdrawal of the petition. Leave to withdraw the petition. Prayer is allowed. You write the learned counsel for the petitioner seeks leave to withdraw the instant petition as the court is otherwise inclined to dismiss the petition. Fools, the prayer is allowed, petition is dismissed on withdrawal.
Much obliged.
Item number 2.
Met with the lordship. My lord, this is a bail application lordship in an NDPS case lordship. The trial is going on lordship.
This year will be
Now
required.
there may be call.
TCR, scan copy of TCR.
Page B.
Oblige.
Item number 3.
Wait, please, Your Honor. Regular bail application, UAP Act is involved, Lordship. CD may be called.
CD.
Another connected case is fixed on 7th of May, Lordship.
All right, 7 did you?
7-5.
Along with, number is there.
Yes, Lordship. BA number 763 of 26. 763. 763 of 26.
Item number 4.
Oh,
BA or AB?
BA, Lordship.
Huh? BA.
Met with the lordship. Case diary may be called for the NDPS.
Along with FSL report also.
5th of May. Deep level. 5th of May.
6.
5.
Number 5.
Wait, please, your lordship, the petitioner is behind the bar for the last 8 months, lordship, postco matter, lordship, but while arresting the petitioner, lordship, section 36 has not been followed, lordship.
Charge sheet submitted,
Lordship submitted as one witness examined, lordship,
TCR,
notice and TCR,
scanned copy
lordship,
of TCR.
notice and TCR, lordship.
What notice? Oh, notice to respondent number.
Lordship,
Notice to respondent number. Scanned copy of TCR along with CD.
14 May.
lordship, can it be on 7 May, lordship? 7 or 8 May? 7 or 8 May? TCR, I have now read.
8 May.
It will.
Oblige, your lordship.
Item number 6.
My pleasure, lordship. Lordship, notice to the respondent, POCSO matter and the case diary.
Same on CD. And then notice to respondent number 2.
Date.
Even May.
Deeply obliged.
11 May.
Supplementary 42.
No, this is under section 483 BNS Act. And is a POCSO milord. So milord, and now milord, today milord, 49 days. And 60 days milord is still period under section 12 of the POCSO Act milord. So 5 years, 3 years punishment. So 3 years punishment under section 12 of the POCSO Act. So now today milord 49 days, only 11 days left. So Martina milord on 5th it will be 60. So notice may go milord, CD may call for with the
Same.
before that.
Notice to respondent number 2 CD.
Yeah,
Let's begin
every-
on next week,
4th or 5th milord,
4th of May.
4th milord.
Maybe 7.
Lordship, this is a POSCO matter, your lordship, notice to be issued upon respondent number 2, your lordship.
CD and notice to respondent number 2.
Oblige.
12 May. Item number 8.
May it please, Milord. You do POCSO matter, lordship will find the FIR at page 17, page number 17. Now, there are 2 FIRs, my lord. Same victim, same accused. The other bail petition, my lord, has unfortunately has not been listed. Now, this is the second FIR, my lord, page number 17. May I read, my lord? Lordship has found.
Page
17,
11.
my lord, 17. This was the first FIR. For that, we have also filed bail, but it has not been listed.
2 affairs against you.
Yes, my lord. Same victim, same accused.
Yes.
Lordship, page 17 for a moment. May I read, my lord? With due respect, I humbly submit that on 2/3/2026, this was the first cause of action, my lord. My minor daughter, so-and-so, aged 17 years, was kidnapped by the person mentioned below. In this connection, a written complaint was lodged at Blasipara Police Outpost bearing so-and-so, and the said case is currently under investigation. That was the reference of that first case. However, it is a matter of deep grief and regret that last night on 17/2/2026, look, there will be some issue 17, not 72, there will be 17/3. My sincere apologies, my lord, that's for drafting error. That will be 17/3/2026, my lord. Between approximately 11 to 11:45 PM, my lord, the aforesaid person entered my house unauthorizedly, forcibly gagged my minor daughter by pressing cloth over her mouth and raped her. Later, hearing my daughter's screams,
Yes, what is this?
My lordship. The petitioner is being a resident of Mazuli, my lord, and is the owner of a tractor, my lord, and other vehicle, my lord. From his residence, my lord, 30 liters, my lord, of 3 containers of diesel, my lord, was recovered. As essential, my lord, section 7 of the essential commodities, it is valuable, my lord. Even Malad, there is not a whisper that my 30T, 317 and Malad 287, there is no ingredients, madam, protect the section 4. Only my essential component that is section 7. That is my value section, madam. And section 23, this is petroleum, this is also value, madam. And in the plain reading of the madam, there is not a whisper that madam, these products are stolen property. 30 liters of 3 containers, madam. There is 19 liters of diesel, madam. The Mazuli, madam. I have a owner of a tractor, madam. The first part is better. So one Manda Hitesor does and Devo, they were arrested. I have no relation with them.
Otherwise, he's a name accused in the FIR option.
On the basis of a statement of Hitesor and Devo, my residence is such.
During interrogation also,
Did-
the third
interrogation-
paragraph, last slide.
Last time.
Illegal business has been running for a long time under the direction of Forest Borough, the present petitioner.
What is the non-billable section here?
Well, 30, well, 317. There is not a whisper that these are stolen properties.
Suspected to be stolen, because they have found
Well,
without any
But
very light.
those persons are already arrested, that Hitesor does and Devo Morang. I have already annexed.
If these are stolen, then there should have been FIR from the
There
owner.
is no FIR.
If it is stolen property, then there should be an FIR from the owner.
There is.
But where from they have collected, that is not known.
So let him appear and satisfy the IO. How he has come into possession of this. At learned counsel for the petitioner on an additional PP. This is an application under so and so. The principal allegation against the present petitioner is that certain quantities of diesel were recovered from his residence and the same are suspected to be stolen properties, stolen right, materials. Full stop. It is submitted on behalf of the petitioner that the petitioner is the owner of a what tractor?
One tractor.
Owner of
And
a
one
tractor.
Bolero car.
Both.
But diesel one.
Huh?
Madam?
Owner of what tractor or bolero?
Tractor, both, man.
One owner of a tractor as well as one bolero vehicle running on diesel. And therefore the diesel has been stored for the purpose of running the said vehicles. Para call for the CD. Para having regard to the nature of the allegations, it is provided that in the event of his arrest, the petitioner shall be released on interim bail of rupees 50,000 with 2 sureties of like amount to the satisfaction of the arresting authority.
Gormore police station, Majuli.
It is further provided that the petitioner shall appear before the IO within a period of 10 days from today for the purpose of interrogation. And that he shall not tamper with the evidence or try to influence the witnesses in any manner. List again on. Okay.
Deep load.
Get to discount.
15.
Admission item 10.
Yes.
May I please, Your Lordship, in this case, I am appearing before respondent number 8, my lord. What happened in this case, they have sought for the prayer portion is by that they have for CBI investigation in a pending case, my lord. ERC case number 14510 so and so.
He not will appear. He's in Lakes in court number 5.
No, we were submitting something.
Now, what was in this case was already this court has quashed the petition, the charges, man, frame against him. On the ground that there was a malfunctioning regarding preparation of CGLs.
Mhm.
So that order has had to put brought in the record, man. So at least 10 days time, man. Justice Chaudhary Malay has passed the order. I appeared before the court.
Cost.
Was.
Or you are asking for what? CBI investigation?
Now, what has happened is they have made the accused person a witness. And the witness, he is not doing business here. He is a resident of Punjab. And the accused who is doing business here,
Yes.
you can understand.
Yes.
And their own officer in a previous inquiry found materials against this person.
Anyway, I'll let it be bring in on whatever order passed by the
You are appearing for
respondent number 8.
learned counsel for the petitioner,
Yes, sir.
Mr. P. Kotoki, learned counsel appearing for
7.
Seven.
CBI, 7.
respondent number 7, CBI, praised for some time to place on record an order passed by the bench of this court. Hence, list the matter again on next week.
2 weeks files, yes.
14 men.
Maybe 16 men. 18 men.
18. Item number 11.
16 maybe.
Lordship, 18th, I will be out of session for demand for that matter. 19th,
19th.
No, 19.
May I please, Your Lordship, in this case, my lord,
Mediation
Yes,
failed.
my lord, matter may be adjourned for the day, my lord, because the new advocate has been engaged, my lord, and he will move the case. After 10 days, mate.
It is submitted that petitioner has engaged new counsel and accordingly adjournment is sought. Hence, list the matter again on
After 2 weeks, my lord.
Lordship, I am appearing for respondent number 3.
3 and 4 Kunkun appeal proceeding. Your names are shown.
Much obliged.
Published.
Item number 12.
May I please, your lordship?
Yes,
Your lordship may kindly pass over for time being.
timing.
13.
May I please, Your Lordship? Earlier occasion, LCR was called for, my lord. We are challenging the
Order taking cognizance against the petitioner under section 3 by the special court POCSO. The FIR is page number 19, my lord. Present petitioner is the 3 brothers and and father of the main accused, my lord. 19 is the FIR. May I read, my lord?
Before my learned friends starts, Lordship, let the other party be appeared, Lordship. because
Already appeared. Already will file
today they are
their,
absent, Lord.
they also filed their objection also, my lord.
So without hearing the other party, Lordship,
Lord-
POCSO matter,
Lordship can fix.
their
in
name
your-
has been shown in the cause list, Lordship.
Lord- Your lordship has already stated the proceeding before the learned court below, my lord. And separate proceeding is going before the juvenile justice board against the main accused, my lord. And page 40 is the cognizance order.
Legible copies are now available. Last order was there.
Lordship, I have to,
There was a last order, say the PP had submitted that not a single page is legible. TCR to করছো প্রেসলি আইছে নাকি নতুন কেন সেম থিং I think it's the same set. Fresh set has not come, I think.
Call করা বা লিখতে হবে সেটা।
Lordship,
এখানে দেখে দেখুন।
it's not legible at all.
Statement পেয়ে নেন না?
Statement or not.
All right, heard learned counsel for the petitioner and learned additional PP. By order dated 20/01/26. The learned special judge POCSO Kamrup Amingam was directed to ensure that legible and complete set of the TCR is sent as the scanned copy of the TCR was not legible. However, no such fresh set of scanned copy of the legible copy of the TCR is available. Full stop. Issue reminder to the learned special judge POCSO Kamrup Amingam to furnish legible copy, scanned copy of the TCR before the next date fixed. Release the matter again on
Earlier interim order that may be continued.
interim order first earlier continue till the next date of list.
In hearing PA 40,
Please, your lordship. As per office note, my lord, I have checked the office note. Service will complete on 9/2/26, my lord.
Service completed, Lord.
Lordship can appoint a amicus curiae.
Alright, heard learned counsel for the petition and learned additional PP as per office note service is complete, but however none appears for the petitioner. Accordingly, Mr. So and so is appointed as amicus to represent the respondent number 2. Extra copy be furnished to the learned amicus. List again on.
Six five.
Amicus curiae has been appointed, my lord. Obliged.
List con live.
Lordship, in this case, my lord, DNA test report was called for mine. And my lord, the petitioner obtained the certified copy from the trial court now. May I produce it, lordship?
My lord, as per the last order, my lord, DNA report was called for, my lord. Then we have communicated with the investigating officer, my lord, along with the OC of the PS, my lord. They have informed us that, my lord, the report has already been sent to the trial court, my lord. Yes.
My lord, page 3, lord.
So no match. Baby's matches with the mother, but not with the.
My lord, only, my lord, as per the DNA report, my lord. If lordship is, my lord, gives a finding, my lord, it will hamper the
I
trial.
will not give a finding, but prima facie it appears.
Only for the purpose of
For the,
disposing. of the
only
case.
for the purpose of bail.
Yes, lord.
Heard Mr. Learned counsel for the accused petitioner. Also heard Mr. R.J. Borwell on an additional public prosecution decision. Application under order dated 26/2/26. And উপৰত দিব, Miss so and so, you are appearing? Yes, appears. Respondent number 2. The allegations as contained in the FIR dated 5/10/25. The petitioner had taken the minor victim forcibly inside his shop and committed rape upon her, as a result of which she became pregnant. And subsequently gave birth to a male child on 26/09/25. Full stop. It appears that during the course of investigation, the IO had collected the blood samples of the victim, the child, as well as that of the accused petitioner, and sent the same for forensic examination, the certified copy of the report of which has been placed before the court today. Full stop. The perusal of the said report indicates that the DNA sample of the victim of the child matches with that of the victim, but not with that of the accused petitioner. Having regard to the same, without making any observations on the merits of the prosecution case, I am of the view that the petitioner may be released on bail at this stage. Full stop. Accordingly, it is directed that the accused petitioner shall be released on bail of rupees 50,000 with true sureties of like amount to the satisfaction of the learned court below. It is further provided that the petitioner shall continue to cooperate with the investigation and shall not try to influence the witnesses in any manner. Petition stands disposed of accordingly. The report of the DFS be kept on record. Certified copy of the report kept on record.
Deeply approved.
Number 16.
এতিয়া এভেইলেবল আছে নে নাই চাই ল'ব, খবৰ কৰি ল'ব, নহ'লে আকৌ বেলেগ দিব লাগিব।
Worship, in this matter, I am to file my objections. I have received the objections, but these are defective, Lordship. I have to get it corrected. Lordship, it grant me 10 days time to file my objections, Lordship.
We'd heard learned counsel for the petitioner and Mr. R.K. Dev Chaudhary, learned counsel representing NCB. Who seeks 10 days time to file objection on the basis of the instructions already received. Full stop. accordingly, list the matter on 10 দিনের time. Hmm?
13 Lordship. 17 Lordship, today's 75 days is behind our petitioner. 90 days is mandatory. 3 times CD, up-to-date CD was called for, my lord. We have received the up-to-date CD, my lord. And along with the FSL report of the arms, my lord, which were recovered and seized, my lord. And I say, and as per the FSL report, my lord, the arms are serviceable, my lord. Handmade arms. This, my lord, against the active person, my lord. The shown is case, main same offense, 2 cases registered. So one under wildlife, this case released on bail. This one is for arms, so let's say separately registered. Offense is same.
Offense is only under Arms Act, not forest offense. Huh?
Here, let's say only arms set. Today is 75 days, that's it.
No, this arm was recovered from whom? That is from Bimal Pachung.
Let's say.
Hmm? Oh, there are 4 petitioners.
Petitioner number 2.
Huh?
Petitioner number 2 is Bimal Pasung.
It was from Bimal Pachung that this was recovered.
Plus Bimal Pasung and another one. That's it. Bimal Pasung and Bhigu Pegu, my lord.
They were detained together. Then search operation was conducted in the house of Bimal Pachung.
2-3 times lawsuit released on PR bond also before arrest. Them lawsuit. Bimal Pasung is the petitioner number 2. It's
Is this covered by 21A? Arms, earlier case, you were granted bail. That was under forest offenses. Now in this case, only under Arms Act, 25(1)(a).
This case lawsuit,
Huh?
25(1) capital A.
Yes.
Shown in a case, lordship, this one.
What is 25(1) capital A? Is a handmade gun covered by that?
For the possession case, any prohibited arm.
Arms Act. Court Master. Arms Act. Arms Act. It's only applicable to automatic weapons.
Prohibited arm, it will not come under prohibited arm.
So this will come under which section? I think it's a bailable section, probably. Or no, at least the detention is not 90 days, I think.
25(1) small a will come, my lord.
Even 1A will be 90 days.
90.
How many days?
75 days. High calculation 77 days, subject to correction.
7 days. And what is the stage? Third learned counsel for the petitioner. Condition, PP. This is an application, so and so. The case of the prosecution briefly put is that upon statements of one co-accused, a search was made in the house of the petitioner number 4, Bimal Pachung, and a single barrel 12-bore gun was recovered. The other petitioners were also arrested on the basis of statements of the accomplices. Is Biswarup Mili is also a petitioner?
Sir, Millie is the mother accused person, my lord, who was initially apprehended, my lord.
And is he a petitioner?
No, no, not the petitioner, my lord. Not the petitioner. Yes, Koilini is also. Sir, no, I haven't. Sir, Millie, we take it as Koilini.
Statement of co-accused Biswarup Mili within bracket Dakar, paragraph 2 page. Full stop. Although the case is registered under section 25 within bracket 1 dash capital A bracket close of the Arms Act, which concerns prohibited arms, comma, that is automatic weapons, comma, the present case appears to be covered by section 25 1 small a within bracket small a. Full stop. Be that as it may, having regard to the fact that the petitioners have been arrested on the basis of statements of the co-accused and that they have already spent 77 days behind bars, comma, the prayer for bail is allowed. The accused petitioners shall be released on bail of rupees 50,000, two sureties each of like amount to the satisfaction of the learned. Which court?
Lawsuit, SDGM,
Further provided that
go for.
petitioners
System
shall
travel.
cooperate with the investigation and shall not try to tamper with the evidence. Petition stands disposed of accordingly.
Yes, sir. My submission may be recorded, madam, regarding the FSL report and the further investigation.
Learned additional PP submits that the matter is pending for further investigation. And FSL report. FSL report.
The arms are my lord, firearms are my, and it is serviceable, madam.
No, not and FSL report, the further investigation and that FSL report reveals that the recovered arm is serviceable.
Look, in this case, my lord, the original case that was called for, my lord. So there is a report from the, my lord, the learned trial court, my lord. The case that was as per the trial court report, my lord, that is marked as flagged A. The original case that was not forwarded to the trial court along with the final form, my lord, success. So my trial court has already, my lord, intimated the matter to the concerned officer in charge. So that, my lord, this original case diary can be forwarded to this honorable court through special messenger, my lord. That flag A, my lord, lordship may kindly peruse.
But it's not there. Not originally is not there. This is dated only 24. Hardly 3 days, 4 days.
Next week, my lord, that response.
For the petitioner and learned. Petitional people. It appears that appears from the letter of the learned special judge NDPS Karbiang Long Difu to the assistant register Gauhati High Court that the original case diary was not submitted along with the charge sheet and the learned special judge has accordingly intimated the OC of Delhi PS to furnish the original CD to this court by special messenger by his letter dated 20/04/26. Full stop. However, the original CD has not been received today. Full stop. Since the intimation was sent only 3 days ago, 4 days ago. Full stop. Further time is granted to submit the original CD. Run an additional PP2. Intimate the OC Delhi PS to submit the original CD on the next date fixed. List again on 8th of May.
Lordship, in the first week of the May, can be given third or second or?
Second is more to so. Take it, like copy of the order, maybe
Copy of the order be furnished to learned edition. Mr. RJ Borwal, learned additional PP.
Lordship, may can be fixed on
I'm-
fifth, Lordship, on fifth.
Fifth one,
6th.
6th of May.
Obliged.
Item number 21.
Made results. Here the scan copy was called for, my lord. Scan copy was called for and the others as was, others appeared on last occasion today, my lord. The informant side. People. He's, no, here, my lord. I have checked the reports with the lordship. Look in the reports, my lord, should find that statement of the girl as well as her. Both the statements are there in the record, my lord. And here, if you should kindly see the FIR, my lord, FIR was logged on, my lord. 12, on 28/1, my lord, page 12 is the FIR, my lord. Lost by the mother, my lord, and here, my lord, the victim is around, nearing 16, my lord, 15 years, 7 months, my lord, and the boy, my accused before lordship, he is 19 plus, my lord. And
22.
Hey, please, my lord. So allegations are under NDPS Act, my lord, 21B, 25 and 29, my lord. My lord, I am not actually involved in the crime, my lord. On that day, my lord, I went to the house of one Raju Ahmed, my lord. And because he is my neighbor, my lord, I went there, my lord. And from somewhere the police authorities came and I was caught, my lord. That is my case, my lord.
We have received the case there, my lord. It is pending to collect the FSL report, my lord. So may I pray, my lord, let the matter come up on next week, my lord.
My lord,
8, my lord.
My lord, pursuant to what my senior friend has just stated, my lord, already 45 days, my lord, I am in custody, my lord, for no fault of mine. I had just paid a visit, my
No,
lord.
my lord, the Caesar has
At
been
that
made,
time-
my lord, in as per the Caesar list, my lord, that contraband also seized from his possession, my lord.
No, my lord, nowhere it is stated that it has been seized from my possession. It was found in the possession of the house. That
As per the
house is
Caesar list,
not
I'm
mine, my lord. I went there, my lord. It is the house of one Mr. Raju Ahmed who happens to be my neighbor. I did not know that he was involved in all these scenes, my lord. But it was my bad luck, my lord, on that day. So I pray, my lord, interim bail may be granted. What my senior friend is saying, my lord, that may happen, my lord. FSL may come, but
Let
till
it
then
come.
I may be granted interim protection.
Let it
Interim
be on-
bail, I may be.
On 4th of May, my lord.
Till then, my lord, some interim, my lord. I may be, because my lord, 45 days, my lord, I'm having a family, my lord, children, my lord. 45 days already in custody for no fault of mine, my lord. I pray before this honorable court. Some relief, my lord, at least till then. 45 days already behind the bars.
Where is the seizure list?
My lord, may kindly have, my lord, page 19, 195 of the petition.
Original is at page 21,
Yes,
my
my
lord.
lord. Original is- Right. My lord, nowhere it is illustrated that it has been found in my custody. It is not my house also.
Nothing is there in the seizure list stating explicitly that it
That
was recovered from his
That is.
person. It is saying possession. Possession where? From the house?
Page number 21, my lord. Name and particulars of the person from whom seized, my lord. Raju Ahmed, then my lord, serial number 2,
No, my lord.
Fazul Haq.
Then why does he not say upon body search it has been found?
Yes. Description part, it is nowhere illustrated.
My lord, that part will also be.
Where is the
clear from
notice under
FIR.
section 50?
It will be clear from the FIR, my lord.
Is the notice under section 50 available in the CD?
My lord. With respect of Raju Ali also is available, my lord.
My lord, I am Faisal Haq. I am not Raju.
Yes, I am just checking, man. Yes, my lord. That is available. Yes,
It is one green color soap box. One green color soap box containing some brown colored powder substances. Description of article seized, seizure list. So if it is one box, it cannot be recovered from two persons. Now the other person will also come and say that it was not recovered from me.
No, my lord, if lordship may come to, kindly come to page number 17, my lord.
Second paragraph.
Second paragraph, middle portion, my lord. In their presence, a search was conducted at the suspected house where two individuals identified as Raju Ahmed, son of so-and-so, and Faizul Haq, son of so-and-so, were found in a meeting inside a room. A meticulous search led to the recovery of one soap box containing suspected heroin of two mobile phones from their possession, my lord.
One soap
One.
box, my lord. One-
And it was found.
They
from the
may be
house.
together, but
Yes.
I'm a neighbor, my lord.
These are, my lord, organized crime, my lord.
very
They
difficult.
knows.
If
And
things are,
that is why, my lord, section, my lord.
if things are
29
written
is
down
also
in
there.
this manner, it is very difficult for us to hold. Anyway, this is intermediate quantity.
Yes, my.
Is it not? That is sufficient doubt is there as to from whom it was actually recovered. Heard learned counsel for the petitioner and learned additional PP. This is an application under so and so. The brief facts of the case, page 26, para 3. It is submitted by learned counsel for the petitioner that the present petitioner is a neighbor of the co-accused Raju Ahmed, and the recovery was made in the residence of Raju Ahmed, which on that day the present petitioner had visited when the police arrived. Full stop. It is further submitted that the no recovery was made from the possession of the present petitioner. Para. On the other hand, learned additional PP submits that both the present petitioner as well as co-accused Raju Ahmed were found sitting together, and as per seizure list, the recovery was made from their possession. Full stop. Para, it is not in dispute that the recovery relates to intermediate quantity. Full stop. It is further noticed from the seizure list that only one soap box containing suspected heroin was recovered, and obviously one box cannot be recovered from the persons of from the possession of two persons upon body search from a. I have also perused the notice under section 50 of the NDPS Acts concerning search of body and belongings of the suspected accused. The case diary nowhere reveals specifically as to from whose possession the recovery of one soap box containing suspected heroin was made. Full stop. Para, having regard to the above as well as the fact that the petitioner has already spent 45 days behind custody, comma, further detention of the petitioner is not warranted in the facts and circumstances of the present case. Para, Consequently, the prayer for bail is allowed.
My objection may be recorded, my lord.
Yes, we have recorded already.
I'm so obliged, my lord.
50,000 should see satisfaction of so and so. Further provided that shall not tamper with the evidence or influence the witnesses in any manner. Send back the CD.
Item 23,
Here in this case, his diary was called for lordship.
In this case, charge sheet submitted, my lord.
In that case, lordship may kindly call for the trial court record. lordship.
Already. It is submitted that CS has been submitted by CS number.
Number 28 of 2026, dated 16/4/2026.
Hence, call for the scan copy of the TCR along with CD. List again on.
Obliged.
even me. Twenty-four,
Lordship, that petitioner is in custody for the last 50 days, lordship, that intermediate quantity and quantity recovered is lordship 12.4 gram of heroin. And commercial quantity is 250 gram, lordship. Much below that commercial quantity, considering the length of detention. Mandatory period is 60 days. I mean, he is already 50 days custody, first time offender, lordship. Page 16 is the FIR.
Age?
60, 16.
So possessor, it was directly recovered from your possession.
The 12.4 gram was the actual weight of the contraband, lordship. That your lordship will find page 25. That is the order of the learned trial, the session, the special. judge. Therefore,
With container, my lord, it was 13.1, without container, my lord, 12.4, my lord. And on the basis of my lord, prior information, my lord, he was apprehended, my lord.
50 days, lordship, that length of detention, lordship may consider. And there is no allegation that he was earlier involved in similar activities, lordship. That allegation, the antecedent is not there.
That is a given.
Lordship. That is there. And 50 days, lordship, that may lordship may consider.
It's pending to, my lord, collect the FSL report, my lord. The FSL report is yet to receive by the investigating officer, my lord.
Okay, we'll see.
Obliged.
Timber.
finding item 12,
नहीं দুটা বেল হিয়ারিং আছিল ন আৰু বেল কিটা শেষ কৰি দিয়া just take a
Where is your lordship?
এইটো আৰম্ভ হলে বাকী নহবতো আৰু ডেলিটা শেষ কৰি দিম এইবিলাক মানুহ
27.
May I please, your lordship? My lord,
CD received.
my lord, petitioner was in interim bail, my lord. And my lord, he duly appeared before the IO and submitted his statement, my lord. My lord, in this case, my lord, FIR is page 13 is the vernacular and 5 copy is, my lord, page 10 onwards, my lord. Only thing, page 10, my lord. Here, my lord, the police, my lord, seized the house of the one Jauddin and his brothers, and some, my lord.
You are Habibur Rahman.
Yes, my lord. I am not at all at the place of occurrence, no involvement in this case, my lord. And my lord, it is only on the basis of the.
Yes, what is his involvement?
So far as the seized suspected beef has been recovered from the person, that is from the person's house, and he has implicated the present petitioner. And the statement of the present petitioner also revealed the fact that he is also involved in the said business of illegal selling of beef. And lordship, so far as the seized exhibit, that is a sample of the suspected beef has been sent for FSL to ascertain whether those are the cow's meat or not. So that report is awaited also.
My humble submission, my lord. My lord, all the direct accused, my lord, all the 3 persons who are in custody, my lord, are already released on bail. My lord, since my lord, this person, my lord, is not available in the place of occurrence, my lord. Nothing found from his the place, and he resides from 1 kilometer distance from this place, my lord. This-
May I read his statement or
Hmm?
the petitioner statement? May I read his statement?
Yes.
মোৰ নাম ওপৰত দিয়াৰ দৰে সত্য হয়, মোৰ বয়স 44, মই ব্যৱসায় কৰোঁ। মোক ক'ব লগা ইমানেই যে মই আৰু মোৰ ওচৰত তাজউদ্দিন, বদৰুদ্দিন and জিয়াউদ্দিনে আজি বহু দিনৰ পৰা গৰু মাংস বিক্ৰীৰ লগত জড়িত হৈ আছো। আমি গৰু মাংস তিনচুকীয়া মাৰ্কেটৰ পৰা ক্ৰয় কৰি আনো আৰু ঘৰতে ৰাখি বিক্ৰী কৰোঁ। যোৱা ইংৰাজী 24 তাৰিখে তিনচুকীয়াৰ পৰা বিক্ৰীৰ বাবে তাজউদ্দিনৰ ঘৰত ৰাখি থোৱা প্ৰায় 10 কেজি মান গৰু মাংস পুলিচে পাই জব্দ কৰে। So same sort of statements has been given
That is
by
my
the
lord
co-accused
statement.
also.
That is my lord statement that Jauddin kept in his house, my lord. Let my lord.
You heard learned counsel for the petitioner and learned additional PP. This is an application under so and so. The allegation briefly stated is that the present petitioner was involved in the business of selling beef along with the co-accused persons, and that on what is the date of occurrence?
3/2/26, my lord.
On 3/2/26. A certain quantity of suspected beef was recovered from the house of co-accused Muhammad Tajuddin. Full stop. The FSL report in respect of the, it is received in respect of the seized suspected beef is yet to be received. Para. Learned additional PP has placed the statement of the accused petitioner before the IO, which is self-implicatory in nature, and has also placed the statements of other co-accused. From the above, it appears that the case against the present petitioner is based on the statements of co-accused persons, some of which whom were earlier arrested and have already been granted bail. Para. Having regard to the law laid down by the Honorable Apex Court, that the statements of co-accused cannot be relied upon for the purpose of deciding bail application. I'll give the citation. The prayer for bail is allowed prayer for as bail is allowed. Accordingly, it is provided that the petitioner so and so in the event of his arresting connection with the aforesaid case shall be released on pre-arrest bail of rupees 50,000 with 2 securities of like amount to the satisfaction of the arresting authority. It is further provided that the petitioner shall cooperate with the investigation and shall not try to influence the witnesses in any manner. Petitioner,
Master bless.
please
Biplav Rai.
send back the CD.
28.
In this case, lordship CD was called for. And there is an interim lordship, accordingly I appear before the IO. CD has given.
Not received. CD not received. List again on so and so interim order passed earlier to continue till the date of exercise.
29. May it please your lordship. Lord, this is an heavy, my lord, and CD was called for, my lord.
That is also not received, lordship.
I am not on interim, my lord. Short date may be given.
CD not received. List again on 5th of May. Order or kiba ta item ta asile tu moti diya yes. Item access page order to ses korichu.
Water item 30.
Your Lordship, we have received affidavit in opposition. We will file affidavit in reply on Monday.
Learned counsel for the petitioner who submits that he wishes to file reply to the affidavit in opposition submitted by the respondent. Hence, is the matter again on
27.
20.
44 আছে নাকি? 44. 44.
Your lordship. Whether some instruction was called from. Because in my additional affidavit manner, there is a letter written by the Gujarat police manner by which stated that the investigation has been completed and nothing found against that petitioner, which was account was freezed due to a complaint from the Gujarat policeman.
Yeah, this is from OC Silchar PS. What about the Gujarat verification?
We have received that only.
Petitioner has brought on record a letter dated 31/12/25, written by Inspector of Police, this Jamnagar, Gujarat,
Yes, sir.
stating that investigation is completed and no objectionable matter found in this, in respect of this account. So you were supposed to verify that, not Silchar.
We have received that only, but we have received that only.
Learned counsel for the petitioner, Federal Learned Council, Learned Additional PP has placed on record a communication from the OC Silchar PS with reference to the aforesaid case. However, the no verification report has been received from the with regard to the letter dated 31/12/25 annexed with the additional affidavit filed by the petitioner. Hence prosecution is directed to seek verification of the aforesaid letter dated 31/12/25 purportedly written by the Inspector of Police, Bedi Marine Police Station, Jamnagar, Gujarat, dated 23/3/26. You'll find it. Is the matter again on?
Help me. Some already, his bank account has been freezed, and it is the salary account of the petitioner. He already retired. His amount.
Date May. You have to write to Gujarat Police.
I have submitted copy earlier, learned my friend.
You have to get this letter verified, that is all, whether he has written that letter or not.
Initially came Bush, thereafter my lord, the P bought happened.
Actually,
If
he
needed,
was
I will submit
gone
him
through the
also.
case, Lordship, and he has submitted me this only.
First minute
Lordship. Because we have to send it to Gujarat, Lordship.
Yes.
12th May would be better, Lordship, if I think.
Yes, because it has to come from Gujarat. Let it be on 12th May.
Finding it in 12.
Miscellaneous item to 9.
Item number 12.
Your Lordship, sorry, Your Lordship, may it be taken after some time. My senior is in court number 8. Matter has been called up.
Some other day, 2 times they have taken time.
All right, please take it on. Belag dina di dia. Just. Oh, my
6 May.
Problem.
itu mati dia gitu baru fix. Hah? Malah ya. Tadi lagi ya. Hearing sir. Malah ya. Itu mana?
32.
Wait, please, Your Lordship.
Yes. Where were we?
My Lord, I was to finish my submissions, my Lord. And for the appellant, I will recall, my Lord, that 861,918 shares, which was held by the father originally. Then, my Lord, for operational convenience, he had also transferred it, my Lord, to the daughter. Ultimately, my Lord, it was to go, my Lord, to the family trust.
Suit filed father's
My Lord, suit filed, my Lord, by the father in 2012. Because, my Lord, the daughter refused to transfer it. There was an order, my lord, passed, my lord, on 13th August 2012, my lord, which was subsisting, my lord, till the impugned order, my lord, came, my lord, dismissing, my lord, our application. In the meantime, my lord, the father also passed away. He also left a will. In the will, my lord, he said that the shares has to go to the family trust. My lord, there's a suit, my lord, before the Calcutta High Court. That's, my lord, for probate of the will. One suit is, my lord, here, my lord, before Jorhat, my lord, court, my lord, for the purpose of, my lord, declaration that, my lord, only, my lord, the father is the owner of the shares. My lord, I had cited, my lord, those judgments, my lord, will recall, my lord, a Privy Council and a Supreme Court, which says the intention of the person who held the shares or who transferred it in both names is very important. And to that, of course, my lord, it fell from court, saying that you couldn't have better intention than this. He himself has filed a suit saying that it belongs to me. And also the will which says that it belongs to him. Because, my lord, there's no presumption, there's no theory of, my lord, when you transfer, my lord, when you have a property yourself, when you hold something yourself, and you transfer it in the name of you and your relative, maybe your wife or daughter, there in India, there's no presumption with regard to theory of advancement. That's, my lord, why I cited, my lord, the Supreme Court judgment. But it's like also nomination, I cited that judgment also. Nomination also doesn't mean that, my lord, the property vests, my lord, in the other person. Because I was the name, my lord, the father was the named first holder and the daughter was the second holder. Now, my lord, will recall, my lord, 15th September 2025, the first court, the trial court, vacated the order which was subsisting and, my lord, dismissed, my lord, my interim application. My lord, I came up in appeal on 24th September, my lord, before my lord. 24th September 2025, there was an order saying that they are not to transfer the shares. The shares, my lord, were then in the DPID of, my lord, 300115. That was, my lord, the DPID of both. Then, my lord, by suppressing the order of 24th September, they had it transferred to their, my lord, own personal DPID. Then, my lord, we made an application, which is also, my lord, on record, my lord, here. That application, we said that it has to go back to, my lord, the original DPID. My lord, by an order of, my lord, 5th my lord, 28th January 2026, which is, my lord, a very detailed, elaborate order. This court then directed, my lord, it has to go back to the original DPID in terms of, my lord, the interim order which was passed, my lord, by this honorable court. That's, my lord, 28th January. Maybe I'll just take, my lord, to that order, which, my lord, holds, my lord, narrates everything, my lord, factually, my lord, it records everything. Then, my lord, 28th January. From there, my lord, they went up to the honorable Supreme Court. Supreme Court, my lord, dismissed the special action. So that's the situation. And, my lord, my submission was that, my lord, Supreme Court also said we are expediting the appeal and the suit. So, my lord, my submission was, my lord, with this order, and, my lord, the share should remain in the original DPID. We should go back, my lord, and have the suit tried out. So, my lord, the suit is ready, my lord. We have filed, my lord, our, my lord, evidence, and, my lord, we will have the. So that is what, my lord, my endeavor was to, my lord, to have this appeal, my lord, disposed of with the order, my lord, which is already subsisting, and to say that it should be maintained in that DPID. In that DPID. Because I'll tell, my lord, what happened, my lord, under the Articles of Association of the company, which overrides, my lord, the Depositories Participants Act, because they rely on the depository participants saying that if someone dies, then it has to go to the second named holder. But, my lord, we showed that the articles say otherwise. Article of Association says that the first named holder will be substituted by the first named holder successor, which means, my lord, here the executor. My learned friend's client doesn't get, my lord, the shares. That is in dispute. The title with regard to the shares as to whether you at all have any right or not, that's the subject matter of the suit. Before that is decided, you can't take away the shares or say that I want to keep it in my own DPID. So, my lord, may I just, my lord, go back, my lord, to that order, and if, my lord, looks at the order, my lord, we can. This is, my lord, we'll find, my lord, the order of this honorable court. That's at page 1, 2. This is the rejoinder. It's, my lord, annexed to the rejoinder affidavit to written objection of the opposite party number 2. It is at page, my lord, 1, 2, 2, 3. How will that? Amit. How will the order be there? My lord?
Order is dated.
My lord, order is dated, my lord, 28th January 2026 of my lord, this honorable court.
Passed in the main case.
Yes, passed in, my lord. My lord,
3983.
Hmm?
3983.
correct, IA 3983. IA Civil 3983 of 2025. Thank you.
This is 3982.
My lord, it is also at page 1222 of the rejoinder affidavit in IA 3216, if my lord wants to. One, two, two, two. 1222 in rejoinder, my lord, in IA 3216. It's annexed, or I don't know whether my lord's
Itu কোনটো হয়? Itu কি হয়? কোনটো হয়? Itu main to be.
because I think my lord, perhaps my lord had marked
Main
my lord
case.
that.
Itu main case. Itu third, yeah. Then year plus itu. 3216.
Yes, my lord, yes. 1222, my lord.
Of the reply.
Yes, my lord, it's a rejoinder affidavit to the written objection of R2. It's annexed there, my lord.
Yes, page.
My lord, 1222. Annexure R4.
No, this is reply to
My lord, rejoinder, my lord, it should,
WO by respondent 3.
there should be a rejoinder, my lord, of the appellant to the affidavit of R2.
This one is reply affidavit of the applicant appellant Somnath Chatterjee to the written objection filed
Yes,
by the
yes, my lord,
opposite party.
perhaps, is it, my lord, if it's IA 3216,
Yes,
yes, my lord, then, my lord, it should be, my lord, page 1222, my lord, 1222, my lord, if it has.
of the IA.
Of the IA, yes, my lord, of the same document, my lord, of the IA.
This
Of the affidavit, yes. Isn't there?
no, this
Yes, my lord, of this, my lord.
this ends in triple figures 9110.
I'm sorry, my lord.
911. If it is an order passed in the IA, then it should be in the IA itself. The order is dated, did you say?
My lord, dated, my lord, 28th January 2026.
No. This may not be in this IA.
IA 3983, my lord, was disposed of.
The 3216. Order is dated
My lord, 28th January 2026.
20 January 2026 or order kuntu thase here to 911 ase last.
If my lord has IA 3216, my lord, we find, my lord, it's annexed to the rejoinder affidavit of Somnath Chatterjee, my lord. It has a heading of.
This is the
In 3216, my lord, there is a rejoinder, my lord. It's
That's right.
rejoinder affidavit by appellant Somnath Chatterjee to written objection filed by opposite party number 2.
opposite party number 2.
Rejoinder affidavit, my lord, that's the document.
1167.
Correct.
The voluminous one, my lord.
I think
But I look
ইয়াতে
at
আছে নেকি?
down.
MP of the DC, that is also.
File করেছো তো না file করে? It starts, my lord, with 1167, my lord, at the first page.
Let us do one thing. You say order dated
My lord, 28th January 2026. Yeah. Is it anywhere else? Just check.
in IA.
Yes, my lord.
Order dated
28
126 in IA.
in IA, my lord, passed in IA 3983 of 2025, but it is part of rejoinder affidavit of IA 3216.
No,
What?
if this order is passed in IA 3983, then it will be
Yes,
there
yes.
in nine.
Well, I think perhaps, my lord, that's the.
Yes,
my
this
lord,
is the
which-
one. Yes, we've got this.
I think that's the rejoinder bill.
Yes. No, no, this is the actual order itself.
Yes, actually, but that's the rejoinder. Yes. Huh? That will be required, no? So that is yours.
Yes.
My lord, kindly look at, my lord, this order. Such and such, paragraph 2, interlocutory application has been filed by the applicant appellant, Mr. Sansaj, under section 151 of Code of Civil Procedure, praying for a direction to respond number 3 for reversion of illegal transfer of 861,918 numbers of equity shares from the joint account of deceased Hemendra Prasad Boru and the respond number 2 Shormila Vijay Shetty to the account of respond number 2 in violation of the order dated 24th September 2025 passed by this court in IS civil number 3216 of 2025 arising out of FAO 62 of 25. Facts relevant for consideration, paragraph 3 of the instant interlocutory application in brief are that the present applicant claims to be the executor of the estate of late Hemendra Prasad Borua, who left behind his last registered will dated September 17, 2012. As per clause 2.1 of the aforesaid will, the 861,918 numbers of equity shares of the respondent one company, namely B&A Limited, which was
Yes, I
held.
think you have taken us through this before.
Yes, my lord, I have taken, my
So
lord.
basically, the relief sought for in this appeal is contained in the order itself.
Correct. Correct, absolutely. And Mulad will find here, Mulad, if Mulad looks at paragraph 37, which is Mulad at internal page 14 of 19. Correct. On 38, Mulad, on perusal of the materials available record, clear that in respect of 8619, sorry,
Yes.
number of 861,918 number of equity shares of respondent of one company. Presently, there are 2 suits pending in 2 different courts. First one is pending in the court of the learned civil judge Jorhat, that is title suit number 41 of 2012, wherein the release of declaration the plaintiff, deceased late Hemendra Prasad Boru, is the sole and absolute owner of 861,918 numbers of equity shares lying in the demat account being such and such. Let's see the DPID IN 300301151 in the name of late Hemendra Prasad Boru and defendant number 2 maintained by respondent 3 has been claimed among other relief. Second suit, that is testamentary suit number 27, which is pending before the High Court of Calcutta, has been filed by the present applicant seeking grant of probate in respect of the last will of late Hemendra Prasad Borua, whereby he has bequeathed the above mentioned equity shares to the Hemen Borua Benevolent and Family Trust. It appears that though the respondent number 2 after the death of late Hemendra Prasad Borua had filed an application for transmission of the above mentioned equity shares in the demat account exclusively held by her way back in 26th October 2013. However, due to the status quo order granted by the trial court in miscellaneous case number 27 of 2012, in the aforesaid title suit, respondent number 3 did not transmit the said shares to the demat account of the respondent number 2. 3 Mulad is HDFC Bank. It also appears that though by the order dated 15th September passed by the trial court in miscellaneous case number 27 of 2012, now this is the impugned order here, the temporary injunction application of the applicant was dismissed and the status quo order was vacated. However, when the said order was impugned by the applicant in connected FAO, this court by its order dated 24th September 2025 passed in IS civil number 3216 of 2020 directed the respondent number 2 not to transfer 86191 numbers of equity shares of BN Limited company lying with the respondent number 3. It appears that on the day when the restraint order was passed, the aforesaid equity shares were lying with respondent number 3 bank in the demand account bearing 30115. Held in the joint names of Hemendra Prasad Borua and respondent number 2. Then 41. It also appears from the submissions made by the learned counsel for respondent 3 as well as the averments made in the interlocutory application number and such filed by the respondent 3 bank that request for transmission of the aforementioned equity shares from DPID 301151 to DPID 300476 was made by the respondent number 2 to the Sandoz House branch of respondent number 3 at Mumbai on 7 November. While making the said request, this is very important, while making the said request, though the bank was informed regarding the order dated 15 September passed in miscellaneous case number 27 of 12, however, no intimation was given to the bank by the respondent number 2 regarding the ad interim order dated 24th September 2025, passed by this court in IA civil number 3216, which prima facie appears to be an act of suppression of material facts. Then 42, it also appears that though the bank had initiated the transmission of aforesaid shares based on request made by the respondent 2, however, later on, after coming to know about the order dated 24th September, put on hold the transmission of the aforesaid shares. Then, my lord, Black's law dictionary, my lord, is discussed, and it was held, my lord, that transfer also means transmission. Then, my lord, kindly look at paragraph 48.
Yes.
Accordingly, respondent number 3 bank is hereby directed to revert the 861918 numbers of equity shares of B&A Limited Company from the demat account of respondent number 2 bearing DPID 300476 client ID Sansach to the demat account of the late Hemendra Prasad Buru and Shomila Vijay Shetty bearing DPID Sansach client
That has
number
been complied
immediately.
with?
Sorry,
That has been complied with?
yes, that's been complied with, and this one they had gone to the Supreme Court.
What happened there?
Malad, Supreme Court Malad will find Malad, they took all these grounds with regard to if Malad, may I just the rejoinder, no? Malad, that is an order Malad of 5th February.
I think we have gone through this before.
Yes, Malad has seen this. Malad, I think Malad's brief was, I don't know why Malad it's not, it was there. Malad, the orders were all there, Malad, in that the rejoinder affidavit.
Okay, we'll find out.
Because Malad, Malad's marking Malad perhaps will be there, Malad, so I don't want to Malad. So Malad, Supreme Court, this is at page 1320 of that same rejoinder affidavit. And it says, Malad, while we are not inclined, I'm reading Malad from the Supreme Court order. While we are not inclined to interfere with the impugned order passed by the High Court, we direct that the FAO and the suit shall be decided expeditiously. Needless to say that the observations made in the impugned order will have no bearing on subsequent proceedings. With this observation, special leave petition is dismissed, pending interlocutory and he stands dismissed. And my lord, what is important, my lord, in the special leave petition, all the points, my lord, which have been argued, which was argued initially, and if my lord is again to argue, with regard to that, no, I can't exercise my voting rights, the shares has to come to me. All those grounds were taken, my lord, before the Honorable Supreme Court. So I am saying, my lord, that the dismissal of the special leave petition also has, my lord, a bearing. Because the Supreme Court has put its seal on the fact that the shares now stand reverted back. Or it's reverted to the original depository participant, my lord, ID account of both the persons. Where, my lord, the late H.P. Boru is also there, and my lord, Shomila Shetty as the second named holder is also there. So I am saying, my lord, while the suit is to be tried, while the trial of the suit, my lord, we are awaiting, there is absolutely no reason to disturb the original interim order which was passed, my lord, on 13th August 2012, which has been continuing, my lord, till 2025. Or, my lord, the order of 24th September 2025, which has been passed, my lord, by this Honorable Court and, my lord, accepted, my lord, by the Honorable Supreme. So, my lord, the dismissal of my petition, and, my lord, surprisingly, my lord, in the impugned order, my lord, will find there was no contest. They also said we will not transfer the shares. And the learned judge, my lord, went ahead, my lord, and dismissed, my lord, saying that no, you had not made out a cause as in 2012. Relying on, my lord, the NSDL rules, which, my lord, we find a little surprising. Because here NSDL rules are not coming into play. NSDL rules are when there is no dispute with regard to the shares. NSDL rules comes in when there's no dispute. Because like, my lord, nomination, my lord, was in nomination, my lord, I cited that judgment also. nomination for procedural advantage, the shares gets transferred in the name of the nominee for procedural advantage, but doesn't mean it belongs to the nominee. Doesn't mean it belongs to the nominee. When there is a dispute with regard to the shares, there's absolutely no reason why, my lord, the person who has not been given the shares, who's the second named holder, should come and say, I want to exercise rights in respect of the shares. Absolutely no right. Yes. My lord, that I believe, my lord, the document now, my lord, has been, the rejoinder affidavit, my lord, is been traced. There, my lord, will kindly just make a note, my lord, of the at 1320, my lord, is the Honorable Supreme Court's order. Perhaps this is, my lord, the
Yes. এখন আছে তো এইটো।
এইটো তাকেতো এতিয়া
এখন তেওঁৰ কপি নেকি? কোৰ্টৰ কপি নহয় না এইটো? হে? এইটো কোৰ্টৰ কপি। ঠিক আছে। থৈ দিয়া ইয়াত। Yes, this is the rejoinder affidavit by.
yes, my lord. In the rejoinder, if my lord looks at, my lord, I'm sorry, my lord, may I just then trouble my lord with, my lord, that order which my lord read from the original file, that is at 1222. 1222, which my lord has already noted. And my lord, then my lord, the special leave petition, my lord, will find. Since my lord, that it has been found now, my lord, may I just show. My lord, in the special leave petition, my lord kindly takes. The special leave petition, my lord, starts at 1241. At 1241, my lord, will find the special leave petition and kindly come to, my lord, 1263 at the bottom. This is part of the special leave petition, part of the grounds, part of, my lord, the issues raised by them. My lord, sees 1260 at the bottom, last paragraph. As regards, it is also pertinent to state
Yes.
that the transmission of the jointly held shares to the instant petitioner demat account neither creates nor confers any additional benefits or dividend in her favor, but is appropriate in as much as the instant petitioner is the lawful and actual joint owner of the said shares, and she only gets right over the company having 38% shares in her name. And then, my lord, also take 1307, where, my lord, the grounds of special leave petition are there.
One three.
1307, page 1307.
Yes.
It says, my lord, leave to appeal is sought for on the following grounds. Because the Honorable High Court, while passing the impugned judgment and order dated 28th January 2026, which, my lord, I showed, failed to appreciate the settled legal distinction between transfer and transmission of shares as recognized by the Company Act of 2013. Thus, the Honorable Court had proceeded on an erroneous premise that the transmission of jointly held equity shares from the joint account of the first and second holder to the second holder's account after the first holder amounted to transfer of shares. Then because the High Court proceeded to allow IA number 3983 without adverting to the fact that the Honorable High Court by its order dated 24th September had merely directed instant petitioner not to transfer the 861918 equity shares of the respondent company that is lying with the respondent bank until the next returnable date and had not issued any restraint whatsoever in respect of the transmission of the said shares. Then note C is very important also, because the Companies Act in section 56 as well as in table F has given completely different meaning to the transfer and transmission of shares. Clause 23I of table F of the Act gives meaning to the transmission as having title over the shares by the survivor after death of a joint holder or by nominees or legal representatives in case of death of sole holder. Whereas clause 19 mentions transfer of shares, which is simply transfer of shares between transferor and transferee. Then, my lord, because clause 9.10 of the bylaws of National Securities Depositors Limited 1996, amended on June 25, framed in excess of powers conferred under Section 26 of the Depository Act, also defined transmission of securities, which is similar to the provision accompanying the relevant portions. My lord, I am showing, my lord, all these issues, my lord, were raised before the Honorable Supreme Court from my lord's, from my lord, this court's order, which did not find favor before the Honorable Supreme Court.
1311. 1311.
Yes.
And just, my lord, one last ground there, J bolcho to, the K.
Okay. J is one for the.
K, my lord, at 1311 K.
The back verification of the thing. Bank mortgage.
That's J.
Bank saving.
Sorry, my lord, J and K, my lord, if looks at my lord 1311. Because the Honorable High Court, however, in the impugned judgment took a wrong view that there was suppression of facts by the petitioner, not pointing about the subsequent order of the High Court while informing the bank about revocation of the status quo order. There was no suppression of facts at all. It was the bank who wanted the revocation of status quo order, and accordingly, same was submitted. And the Honorable High Court's order was only against the petitioner, not to transfer the shares. Same had nothing to do with transmission. Moreover, bank was very much aware of the said order. In K, they say, because the Honorable High Court failed to consider that the instant petitioner is a joint shareholder of 861918 equity shares, and then the mere transmission of the said shares from the joint demat account to the petitioner's demat account only enables her to exercise voting rights and her participation in the company's affairs. Such transmission neither entitles the instant petitioner to receive dividends nor confers any additional benefit, as the petitioner's demat account stood frozen so as to prevent any transfer of shares. In fact, the petitioner had in any event furnished an undertaking before the Honorable Gauhati High Court not to transfer the 861918 shares to any third party, and the respondent bank, being fully aware of the subsequent subsisting restraint on transfer, effected the freezing petitioner's account. Accordingly, transmission of jointly held equity shares petition demat account neither creates nor confers. So, my lord, all these grounds, my lord, were taken. So, my lord, I am saying, my lord, this did not find favor, my lord, with the Honorable Supreme Court, and my lord, the order that, my lord, it should be restored back and remains in, my lord, the original account has, my lord, been, my lord, confirmed. Now, my lord, next, kindly look at Kunta. Now, my lord, the same document. My lord, the SLP order, my lord, which I read out, my lord, that's at page 1320 of this document. My lord, will kindly just make a note of it. 1320, my lord, will find, my lord, the special leave petition, my lord, order. 1320, we are not inclined to interfere with the impugned order passed by the High Court. We direct FIR and suit shall be decided expeditiously. And then, my lord, this Honorable Court's order, my lord, at 1326, which is 12 February, which says shares has to be restored. Then, my lord, ask me, my lord, whether the shares have been restored or not. That is, my lord, at 1328. My lord, on 17 February 2026, my lord, will find. As per order. This one of the bank, the depository partition bank is writing, this one number 3. As per order, we have processed the transaction from demat account DPID 300476 client ID Such to target DPID 301151 client ID Such. Quantity and status quo for transaction is settled. And at the top, my lord, will find subject immediate compliance requirement, non-implementation of Gauhati High Court order dated 20th January, affirmed by Honorable Supreme Court on 5th February, reversion of 861918 shares of BND Limited. My lord, that is, my lord, now transferred, my lord, and my lord, in the original account, my lord, which is there. Now, my lord, will kindly take, my lord, at 1434 of the same document, my lord, annexure R16, my lord, will find, my lord, the original first named holder and second named holder. It is not joint shareholding, but, my lord, first named holder. This is, my lord, the original account opening form.
114?
1434, my lord. That's my lord R16.
Yes.
My lord, we'll find, my lord, here, this is, my lord, the original account opening form. It was, my lord, in the name of Mr. Hemendra Prasad Borua. Then, my lord, at 1435, my lord, we'll find it became, my lord, in the joint name of both. Then, my lord, just one more aspect, if my lord if I may show, though my lord may not be, well, it will be, my lord, why I just want to show, my lord, the articles of association, my lord, was amended. My lord knows, my lord, of a company, my lord, the constitutional document of a company, my lord, is the articles of association. In terms of, my lord, the Companies Act, that's what governs, my lord, the rights of, my lord, the shareholders. Memorandum of association and, my lord, articles of association. It's, my lord, like the rules, my lord, knows of, my lord, any, my lord, company. In the articles, it says that, my lord, if the first named holder dies, then, my lord, in his place, his successor, which means, my lord, in this case, the executor will be substituted. So, second named holder, who's, my lord, Shormila Shetty, doesn't come in. She doesn't automatically become, my lord, the first named holder. Now, this is, my lord, at my lord, Article 43 and 45 of, my lord, the Articles of Association. It is there on record. But, my lord, just kindly take it off from me, my lord. If there's an issue, my lord, I'll show that. They had, my lord, filed a company petition challenging these articles also. That, my lord, company petition, my lord, will find before, my lord, the Company Law Board. If, my lord, kindly comes to 1438.
Yes.
1438, my lord, will find before the Company Law Board, Kolkata Bench at Kolkata, Company Petition 186 of 2013, Shormila Shetty Petitioner versus B&L Limited and others. And in this, my lord, will kindly come to page 6.38, 1467, 6.38 double A. एकदम ओखने नहीं है 1467 देखिए.
Yes.
Well, it sees further, well, let's see 6.38 AA. Further, the alleged amendment to the Article 45 of the Articles of Association claimed to have been made on 6th August 2012, by which the respondents are refusing to register the 861918 shares earlier owned by the petitioner jointly with her father and which are vested with the petitioner solely consequent to his death is subject matter of challenge in the instant company petition. Even during pendency of the company petition, the respondents have sought to give effect to the alleged amendment and are attempting to transpose the respondent number 2. Now, respondent 2, my lord, is Somnath Chatterjee, my lord, who is the executor here. As the primary holder of the shares, such act would be patently illegal, oppressive. At present, the said shareholders belong solely to the petition may attempted to be used for passing resolution meant to be detriment to the interest of the company as well as the petitioner. Then, my lord, 6.38b, alleged amendment in respect of original Article 5 of the Articles of Association has attempted to made on 6th August 2022, contrary to provisions of Companies Act, particularly there relating to nomination. So, my lord, this was the subject matter of another prior proceeding. Now, this company petition, my lord, was dismissed. Sorry, my lord, yes, reliefs. relief, my lord, sees at 1472. Kindly see, my lord, the reliefs, A and C. A, my lord, is declaration 1472. Declaration that the petitioner, my lord, here is Shormila. The response number 2 here is the sole and absolute owner of 861,918 shares held in demat account number 301151, client ID maintained with HDFC Bank Limited. Then, Mullah, this is the same shares. Then C, declaration that the resolution claimed to be passed in annual general meeting held on 6th August regard to the amendment of the articles of the company is bad, illegal, null and void, and of no effect. Now, Mullah, this company petition, Mullah, was dismissed by order dated, Mullah, 13th July 2017. That also, Mullah, I have annexed at page 1478. Same affidavit, Mullah, it was dismissed, Mullah, at by, Mullah, the National Company Law Tribunal, Gauhati. Mullah will find, Mullah, at 1478 at 1485. The company petition, Mullah, gets dismissed. Then, Mullah, they wanted to have this order recalled. That got dismissed. They, Mullah, filed a review. That got dismissed. They went up in appeal. That also got dismissed. So I am only showing, Mullah, that their challenge or, Mullah, their trying to have any right in respect of the shares has failed. I have a suit where I have also asked for declaration. I means, Mullah, the father, late Mullah, which is, Mullah, being pursued. And during the pendency, there's no reason why, Mullah, the status which was existing as, Mullah, before the death, Mullah, should be disturbed. This is, Mullah, are really, Mullah, in that sense, Mullah, the appeal is for that. The short submission is that. That why should, Mullah, with great respect, Mullah, if I put my argument in a question form, why should, Mullah, while, Mullah, the suit is pending, while, Mullah, that you will get an advantage which you never had. You never had voting rights to the shares. You never had any right to the shares. Dividend has always been paid, Mullah, to the first named holder. And even now, Mullah, I had shown that on the last occasion, even now, Mullah, pursuant to, Mullah, orders passed by the Honorable Calcutta High Court.
Dated 27 June 2000.
Dated, Mullah, 27 June
2018.
2018. The dividends are being still distributed, Mullah, deposited in the testator's account.
Separate account.
In a separate account, Mullah, in the name of the estate of Hemendra Prasad. Mullah, I leave, Mullah, lunch. Mullah, I'll take, Mullah, another 10-15 minutes, Mullah, at most, Mullah, immediately.
Complete it.
Yes, Mullah, I can come.
If
Mullah-
Mr. Majumdar is not too hungry.
No, I'm not. Well, if my land friend volunteers to argue for another 1 hour, I have no difficulty.
No, I don't think we should. My
Since-
lord will be.
since
my-
the word
what I'm
15
saying. My
Since
lord.
the word 15 has come out of his mouth, I'll restrict him to that. Don't worry.
In that case, I may be relieved, my lord, because only one more submission, my lord. At 2 o'clock, my lord, one matter is fixed before I'm Justice D. Barua. I'll just, it's content matter, my lord, 2 minutes, I'll then come back.
So we continue.
Yes, then, my lord, I can continue, my lord, at 2, my lord, 15. Huh?
Then
Huh?
in that case, my lord, if.
No, I mean,
Do it at 2 o'clock. I have
after-
no difficulty. After.
After 2 to chole.
Ah. What I'm saying is, my lord, if he's there till 2 o'clock.
Yes, I am there.
Let him argue for another 15 minutes at 2 o'clock with instead of,
Very-
my lord, detaining your lordship.
No, I'm not feeling to detain. I'm ready to hear.
I think, my lord, Mr. Majumdar wants to take, my lord, that 2 minutes to come back. That's
That's all right. I'll come 2 minutes late.
that is, my lord. I think, my lord, has given a perfect solution now.
You inform when you are here.
In that case, my lord, you continue at 2 o'clock,
want
then
to
if
go-
I can
I
come.
want to go with the flow since he's.
Yes, I
he's
just want to finish.
finished it.
Okay, I'm grateful. I'll just finish, my lord. So, my lord, just, my lord, to that 1485, my lord, has already, my lord, looked at, my lord, the company petition being dismissed. My lord, just for the records, my lord, at 1487, my lord, they had asked, my lord, for recalling of that order. 8th April 2022, that was also dismissed. That's my lord, 8th April 2022, page 1487. And my lord, they went to the appellate court and then my lord, they withdrew. So my lord, that's the end of my lord, that chapter where my lord, that company petition stands my lord, dismissed as on today, along with reliefs which they had claimed. Because there will be a question of my lord, constructive res judicata in that sense. So far as his right is concerned. His, sorry, my lord, respond number 2 here, my lord, her right is concerned. Then, my lord, there's one more order, my lord, if I may show, where, my lord, they came before this Honorable High Court, trying, my lord, again to vacate the earlier order. This is, my lord, at page 1526. This is 26 July 2021 at 1526. My lord, this was an challenge under, my lord, the civil division to Article 227. Again, my lord, from one of the orders passed, my lord, by the civil judge TS number 41, when the interim order was subsisting that time. This is a prior proceeding. They just, my lord, kindly have a look. I'm showing, my lord, their conduct as well. 1526 at 1532. Paragraph 15. This court has already agreed that till the probate is granted to Ms. Chatterjee, TS number 41 of 2012 should be kept in abeyance. Therefore, this court is of the opinion that the act of filing the petition before the learned court below seeking an order that TS number 41 2012 stood abated is contrary to the spirit of the order passed by this court in CRP number 47 of 2014 and CRP number 97 2014. I am constrained to hold that the petition miscellaneous filed by the petition is a misleading one. And then, Mullah, they again went up, Mullah, to the Honorable Supreme Court at 1534, and Mullah, the special petition was dismissed. This was when, Mullah, there was a stay with regard to, Mullah, the suit itself. Because subsequently, Mullah, that stay got vacated by this Honorable Court, and Mullah, we could proceed with the suit. Now, Mullah, I just want to show two more documents. Mullah, at I don't know whether I can get it on. Mullah, at where will I get this? Mullah, in the sorry, Mullah, just give me a moment. Where's that letter?
Page 830. Our reply to return objection of bank 398.
My lord, at my lord, in the sorry, my lord, in the reply affidavit of HDFC Bank, my lord, there's an email of 15th October 2025 at page 830. It is in IA what?
That's okay. It's you can read it.
Yes, my lord, I'll just read it. My lord, this is, my lord, the email which was referred to in the 28th January 2026, where, my lord, they disclosed, they only spoke about the 15th September vacating, and they did not, my lord, talk about the order which was passed, my lord, by this Honorable
We have
Court.
gone through that.
Yes, my lord, that is, my lord, at page 830, my lord, of that reply of IA 3982. And, my lord, just the HDFC affidavit, my lord, takes that, my lord, in the same reply affidavit, at page 772 J. Well, this is what one of the HDFC Bank says at 772. They say then that taking calculated and undue advantage of the fact that the aforesaid demat account could be operated from any branch of respondent number 2, respondent number 1, which is one of them, with full knowledge of the subsisting ad interim restraining order dated 24th September 2025 passed by the Honorable Gauhati High Court, deliberately and malafide initiated a request for transmission of shares and intentionally approached the Sandoz branch Mumbai with the sole object of evading and frustrating the said judicial order, knowing that the said branch would be unaware thereof. Consequently, the transmission of shares was processed exclusively at the Sandoz branch Mumbai, which at the relevant time had no knowledge or notice of the said restraining order, as respondent number 1 willfully suppressed and concealed the same and failed to disclose or produce any copy thereof, committing suppression of material facts, playing fraud upon respondent number 2 and the Honorable High Court, and deliberately circumventing the binding effect of a subsisting judicial order. Then, my lord, in the same affidavit, my lord, the bank also says M, that the respondent number 2 states that the alleged transmission of shares occurred solely on account of incomplete and selective disclosure made by respondent number 1, leading to an unintended interbranch communication gap and not due to any willful act, negligence or malafide on the part of either the Sandoz branch or the home branch of the HDFC Bank Limited. So this is one of the stand of one of the bank saying that they had one got that transmission. So just one to summarize one of my arguments now, Mullah. So one, I say that the order of 15 September 2025, which is the impugned order, should be set aside for 3 really grounds. One, that the injunction order was there or the status quo order was there from 13th August 2012. They said we will also not transfer. And what was the status quo order? It was in the original account of both in which it was kept. There's no reason, why it should be transferred to her personal account. Whether she gives an undertaking, doesn't give an undertaking, it's irrelevant. If as on the date of the suit and as on the date of passing away of the Mr. Borua, if this was in one account, it should continue to remain in one account. The learned the trial judge did wrong in dismissing the injunction petition and vacating the order which was there. That's my first submission. Second, is when we came up in appeal, this honorable court has passed an interim order on 24th September 2025, which was later clarified on 28 January 2026, which says no, it has to go back to that same account, revert to the same account. And the Honorable Supreme Court confirmed that. That position, was accepted by the Honorable Supreme Court. So there's no reason, why now, we should go to a position where, the respondent number 2 here, Shormila, would be permitted to deal with the shares again. Because, then it will go out of the estate of Hemendra Prasad Borua. Because of which, probate is also pending. And, the executor is, the one, who can deal with it, under the Succession Act, title vests in him. And now, knows even probate has been done away with. With the latest amendment, I've seen of the Succession Act, because we'll recall, initially it's only some of the cities which required a probate. If you had property within in Calcutta, Bombay, and Madras, you required a probate. Otherwise, probate was also not required.
For having these shares expunged from the state.
And then next, which I had already shown, they also tried to get these shares out of the estate by applying before the Calcutta High Court to say that please delete these shares from the affidavit of assets, which means delete it from the estate. Calcutta High Court refused that. That order, I've shown already, that is there. Pursuant to Calcutta High Court order, dividends are also being deposited in the account of the estate, which is maintained by the executor. And lastly, which is very important, the conduct of this respondent should be taken into account. It does not inspire confidence, it should not inspire confidence in court as to whether at all she should be entitled to any right in respect of the shares. Because of this transmission which was done by suppression. She's also facing a contempt in the Calcutta High Court because she's sold off some of the properties of the mother, where there was an order of injunction, that is also on record.
Mother's property is also pending.
Because mother's will, my lord, probate is also pending. There also, my lord, she sold off some properties, which is, my lord, also, my lord, subject matter of contempt. She's facing that.
Is it habitual?
So, my lord, I submit, my lord, that in view of that, my lord, the order which has been passed by my lord on 24th September 2025, and really, my lord, and coupled with the order of 28th January, they should be, my lord, maintained. And, my lord, we should have, my lord, the suit, my lord, tried out, my lord, as we are progressing with the suit. As, my lord, also directed by the Honorable Supreme Court, my lord, that the suit should be expedited. My lord, those are our submissions, my lord. I'm very grateful. I'm sorry, my lord, I detained, my lord. After lunch.
We'll reassemble after you get here.
Yes.
Well, I'm grateful.
My friend, Mr. Majumdar will. Yes. Lord, regarding the background of the case, Lordship is by now is aware.
Yes.
Now, the appeal is principally filed against the order by which, my lord, the earlier order of status quo was vacated.
Let my learned friend complete his part in the disseminate.
Okay, very well. So, my lord, basically, we want that the injunction should continue and the suit should be proceeded with expeditiously. That is basically what we would like to project. Now, my lord, the basic question is, now this OP number 2 or the defendant number 2, her status is a second holder. Now, end of the day, what falls for consideration is, as a second holder of the shares, what is her right? In terms of the Companies Act or in terms of the Articles of Association of the company. Now, I can appreciate, my lord, somebody is a joint holder. If somebody is a joint holder, the status would be different. But this second holder, this is the status. It's in my humble understanding, it's, my lord, really on the lower pedestal. Now, please come to the impugn order of the learned trial court, whereby the order was vacated, my lord, that your lordships will get in the IA 3982 at page 213. IA 3982 of 2025.
Page 200.
211 it starts, my lord. And the operative portion of the order is at 213. That is the order of injunction which was initially passed by this honorable court.
212 is the order of this court.
Yes.
Yes.
Please come to 213, my lord, the operative portion of the order.
Yes.
It is hereby directed that till the returnable date, the respondent number 2 shall not transfer 8,16,918 shares of B&A Limited lying with the opposite party number 3. Now, my lord, after this order, much water has flown through the Brahmaputra, which by now my learned friend Mr. Banerjee must have apprised your lordships. Eventually, my lord, it was transferred to the account of the demat account of the opposite party number 2. Now, in terms of the last order of this honorable court, now the earlier position has been restored. Now, we are against the order by which, my lord, the injunction was vacated by the trial court. We means, my lord, the Mr. Banerjee, who is the appellant. Now, if your lordship should kindly come to the impugn order of the trial court, please come to page number 421. Please have, my lord, page 420.
Of the same IA.
No, yes, no, it's a part of the FA order.
The order is a long order, my lord. It starts at page number 412. But I'll have your lordship's kind attention to page 420, 421, and 422. This is
In volume B, I think.
Please come to page 420, paragraph 20 towards the bottom of the page. It is submitted that the shares were paid up and purchased by petitioner alone, and only for the purpose of administrative convenience, OP number 2 was taken as a joint owner of the said shares. The said facts will come out only on trial. Very well. Another important fact, as noticed from the pleadings of
This is the order
petitioner-
dated 15/9/25. Yes.
We are against this order. This
The
appeal
FA, it is
against
at,
this order.
is at 412.
Yes, this appeal is directed against this order dated
Uh-huh.
15/9/25, whereby the injunction given by the trial court was vacated. my lord. The said fact will come out only on trial. Now, when it comes, my lord, we all know, my lord, what is cause of action. Cause of action is a bundle of fact, my lord, which enables a party to approach the court of law. If we can establish our case, then we will be entitled to a decree. But when we approach the court with a prima facie case, that is cause of action. Our assertion is, it is my share, I am the owner of the shares. For some administrative reasons, my daughter was made the second holder. She was not made a joint holder. Kindly mark it very carefully. So she was made a joint holder, and for some reason, good or bad, it's my, my lord, affair. So I wanted to revert it back. When she refused, then we went to she went to company law board. Company law board should say, since it's a matter pertaining to share, seek a declaration regarding right, title, and interest. So that is how this suit came to be instituted. Now, kindly see, my lord, this said fact will come out only on trial. Very well. Another important fact, as noticed from the pleadings of the petitioner, is that 947,829 number of shares which were bequeathed to the trust were not transferred to the joint account of the original petitioner with OP number 2. The share which were maintained in a separate account of the petitioner in ICICI Bank were only transferred to that joint account. OP number 2 is one of the children of the original petitioner. Other children or their legal heirs have not challenged the right of OP in respect of those 8,61,000 so-and-so number of shares of our joint account. As the said number of shares are not the trust properties I hold, the balance of convenience also does not lie in favor of the present petitioner. My lord, this view is absolutely wrong, my lord. I'll show why it is wrong. Because the status of a joint holder, a second holder, can be known either from the statutory scheme of the Companies Act, or from the, my lord, Articles of Association. I'll come to that. Now, my lord, this observation of the trial court that other children or their legal heirs have not challenged the right of OP is absolutely wrong. Because, my lord, in the probate proceedings, the other legal heirs of late Hemendra Prasad Borua has filed affidavit in support of the, my lord, the petition appellant before your lordships. So there was not only an incorrect statement was taken note of, it is a, my lord, wrong evaluation of the facts. So when wrong facts were evaluated, what is the question of, my lord, any prima facie satisfaction being derived therefrom? The subject matter of this suit are some shares of B&A company. Thus, if the injunction as prayed for is not granted, the petitioner would not suffer irreparable loss, which cannot be compensated in terms of money. Well, let us visualize a situation. There are 8 lakhs and odd shares. Supposing OP number 2, tomorrow the injunction is not there. She transfers it to 8,50,000 shareholders, persons, Miller. So we'll file suit against 8,50,000 suit. At the end of the day, my lord, a judicial authority must take a rational view. My lord, when we say prima facie case, when we say, my lord, balance of convenience, when we say, my lord, irreparable loss, it all carries some definite legal connotations as is understood in civil jurisprudence. It is not something, my lord, it's not a question of perception. These are all concepts, my lord, which are all judicially evolved and established now. So when we say, my lord, therefore there is no prima facie case, when you are basing your satisfaction on wrong evaluation of facts, how can it be said that there is, my lord? That way, this is an irregularity in the order, my lord. Considering the aforesaid fact, I have not found it a fit case to grant injunction restraining the OP from transferring in any manner 8,61,918 shares of B&A lying with OP number 3 into the account of so-and-so plan, or restraining OP number 3 from transferring 8,61,000 number of shares lying in account of so-and-so and client ID number so-and-so. Hence, the prayer for injunction is rejected. Accordingly, status quo order stands vacated. So-and-so, so-and-so. Now, another important aspect, which in my humble submission, my lord, has got some relevance in the context of this case is, my lord, the original order of status quo was passed way back.
1-3.
In 2012. And, my lord, several proceedings arose out of those orders, my lord. Matter even went to the Supreme Court also. This twice before this Honorable Court, once before the Honorable Supreme Court. I understand my learned friend, Mr. Banerjee, must have brought it to your lordship's notice. Now, everywhere, my lord, even the Supreme Court was of the view, until the main matter is decided, the status quo should be maintained. Even otherwise, my lord, why status quo is required to be maintained? The status quo is required to be maintained so that, my lord, in the event of success, then, my lord, there is no prejudice caused to the parties. Well, these are all simple concepts, my lord. I don't think we need to supplement our arguments with any judgment. Now, therefore, end of the day, here we are confronted with a case where a gentleman called one of the most successful tea planter of the state, H.P. Barua, held so-and-so number of shares. Now, for administrative convenience, he inducted his daughter as second holder, not as a joint holder. Now, for some reason or other, at one point of time, he felt that since it is not in the interest of the company, therefore, he requested the OP number 2 to resign from her position. When she refused, then everything ensued. Now, end of the day, my lord, it is the self-acquired property of Mr. H.P. Barua. It is not a property which is inherited. Therefore, that is also a relevant consideration in the facts of the case. Now, coming to the, my lord, status of the joint holder, like to place the articles of association of the company on the option. As an extra copy. I think lordship is holding a copy, my lord.
In the memo of appeal, sir, it will be page 424.
In the memo of appeal, it is there, my lord. Page 424.
423 it starts.
I'm obliged. Thank you. Yes. My lord will kindly come to page number 424.
Yes.
Please come to 43(1)(i). On the death of a member, including a joint holder, the heirs, executors, administrator, or legal representatives of the member shall be the only person recognized by the company as having title to his interest in the shares.
43(2).
Then 2. On the death of a member who was the first named joint holder on the register of member, his successor, if he is single, or one of his successor, if there are more than one, as may be jointly nominated by the successor, shall be substituted as the first named joint holder in the place. The surviving joint holder or holder can continue to be recorded as a second or subsequent named joint holder after such successor or successors.
She continues.
My lord,
second.
now she is not even, my lord, second joint holder. She is a second holder. There's a difference between second joint holder and a second holder. Now, the end of the day, my lord, when you are asserting your position as a defendant in our suit, what is your legal right? So therefore, on what basis the trial court prima facie came to the conclusion that we do not have a prima facie case? Well, I'm posing a question to myself. Now, on the scheme of, my lord, Article 43, 1 and 2, as a second holder, what is your right? On the contrary, my lord, there is an will. Probate proceeding is going on. The appellant number 1 is the, my lord, person who has now been substituted as the plaintiff by this honorable court. Now, who has a better right, my lord? So, all that I am saying is, please preserve status quo until this suit is decided. My lord, in my humble understanding, my lord, I don't think it's such a matter where lordship should report a very detailed, elaborate hearing, my lord. End of the day.
I wish we could say like the Supreme Court petition dismissed. Or petition granted.
My lord, in this case, my lord, kindly say petition allowed. Otherwise, my lord, we will be in, my lord, difficulty, my lord.
So therefore, my lord, for end of the day, lordship will weigh my right, who has been substituted as a plaintiff by this honorable court to succeed H.P. Borua vis-a-vis a lady, my lord, a second OP number 2, who is not a joint holder, she is a second holder. In the eyes of law, she has no right. Therefore, her resistance, yes, at best can be decided at the trial, my lord. But I don't think the learned trial court therefore was right in coming to the conclusion that this order of status quo, which was passed way back in the year 2012, and which order was tested twice by this honorable court, once by the honorable Supreme Court, though not directly, but it did fail for consideration in one way or the other. And the highest court of the country was of the view that status quo should be maintained. Therefore, my humble submission is, my lord, it's a case where lordship will direct the trial court 6 months or maximum 1 year, my lord. This case should be disposed of and decided. And till then, my lord, the earlier order of 2012, that should be maintained. That is my humble submission. I don't think I should supplement any other effort. My learned friend, Mr. Banerjee, has already elaborated, made the argument. All that I was trying to project was, as a second holder, her right is really very, very limited. And having regard to the nature of the right, the nature of resistance that is sought to be projected, whether it can at all be countenanced in the legal system, my lord, we are governed by.
As I understand, before the learned trial court, they had taken a position that they have no objection if it is not transferred. So, at this stage,
Yes.
are they permitted to resile from that position?
Absolutely.
That is a question, maybe you would like to address on the legal position on this.
No, that's the position, my lord. Now, where is the question now? As suit is going on, let it come to a logical end without disturbing the rights of either of the parties. As I've given that example, my lord, tomorrow, if the injunction is lifted, if tomorrow, my lord, 861,000 persons are transferred this year, then what will happen to us? So which can be very well avoided. Therefore, my humble submission is, my lord.
What I was on with, this is a question that I would normally pose to the counsel for the respondents. That once a party takes a position that they have no objection, they don't need the transfer.
Yes.
But it's a form of a concession.
Yes. Form of a concession.
Is a party allowed to reprobate from that in a higher forum?
Yes.
That is the question of law that I
Yes.
would like to counsels to address from any side.
Yes. I think that my learned friend, Mr. Majumdar, will have to
Yes.
answer, since we also subscribe to that same very view, Mila.
No, but since you will be taking flight after this, that is why I gave you an opportunity. Anyway, if necessary.
Sorry.
No, please, please.
Their case, they said, let it come to me, we will not transfer. That can't be the position. When they say they will not transfer, which means it should be retained in the original share, DPID account, as they say, depository participant, it should stay there. They say, no, give it to me, then we will not transfer. But that is not what we are looking for. It has to be maintained in the same. Otherwise, the estate loses.
Yes.
The estate, my lord, loses, my lord, its control or right, my lord, in respect of the shares. That is, my lord, the difficulty.
And most importantly, my lord, is that claim backed by any legal, law or any statute or anything? That claim,
Correct.
is it backed by any statute?
And in fact, that is why, my lord, we'll see, my lord, before the trial court, we, my lord, did not make any argument at all. We did not make any argument because it was said that we will not transfer the shares. And that is recorded in paragraph 13, my lord, of the impugned order.
That's my humble submission, my lord. I'm deeply aware.
Lord, in this case, Lord, I am opposite party number 3, my lord, HDFC Bank, my lord. Although I have nothing to say about the merits of the case, my lord. Only thing is that they have filed an IA 3982, alleging violation of the injunction order dated 24/9, my lord. So if they are still pressing that application, then I have to, my lord, I have filed only an objection, my lord, and also an application, independent application 4154 to vacate the interim order. Just because they have filed an, my lord, injunction violation or petition, my lord.
It's the appeal, my lord, which is being heard out. So I don't think.
So
my lord,
if
that
it is, if they are not pressing, my lord, I have
No,
nothing
no,
to
they
say,
are
my
not.
lord.
You have
Because-
four respondent number,
3, bank.
3, HDFC.
Already the shares has been already restored, my lord, to the original.
Yes, they
position.
have restored it, my lord. That's what, after, my lord, orders of court, my lord, they finally restored.
So you have no further grievance against them now?
Yes, my lord. If it, my lord, remains restored, my lord, I have quite naturally, my lord, no other, my lord, grievance.
So let's not burden ourselves with that aspect anymore. Yes. I think he said 2 minutes. I think it's half an hour now.
Extremely sorry.
Now, you please ascertain if he is in a position, he would be in a position to address the court today. Otherwise, we'll go ahead with other matters.
Okay.
Eric মাতিলে মই পিছত বেলেগ কাম কৰি লম। Full light, Eric. We'll come back after some time.
At 2 o'clock, it appears there are 2-3 matters at 2 o'clock. My matter is yet to reach, so I have come back here. Well, in this case, as your lordship has already also heard me, we have actually considered their prayer even before the trial court. That the nature of temporary injunction they have prayed, we do not have any objection if we are restrained from transferring the shares to a third party. But somehow the learned trial court has come to a finding that no, you may concede, but if legally the plaintiff himself is not entitled to such a temporary injunction, why should we grant? And the learned trial court has taken 3 valid points based on which their temporary injunction application was rejected. And there are reasons, but I'll go to those paragraphs a little later. But before that matter, I need to point out why I have said in the beginning that I have considered, even before your lordship, I am conceding that if your lordship simply disposes of this application with a direction, or rather with an order of temporary injunction, that we are restrained from transferring those shares to a third party, I have got no difficulty. But it appears, my lord, the kind of prayer made in the plaint and the decree prayed in the suit and the prayer made in the temporary injunction and the prayer now sought to be made in an indirect manner, it is necessary, my lord, to first, my lord, point out what was the order passed by Honorable Justice Midul Kalita first. And then the observation made, maybe 1 line or 2 lines by the Honorable Supreme Court, for the simple purpose of submitting before your lordship or informing this Honorable Court that this Honorable Court is in no way bound by any of the observations made so far in this case, and your lordship is free to at liberty to pass any order your lordship finds fit and proper. For that, my lord, my learned friend has, I am told, read the order passed by Honorable Justice Midul Kalita, but one particular paragraph which is relevant, that is paragraph 45, was not read. So I need to read that, my lord. Your lordship will find in the rejoinder, my lord. Page 1238. I would not have gone into this question, but it becomes relevant because repeated submissions were made that the questions which were raised before the Supreme Court were rejected, or points which were raised by us were rejected, and the matter went to Honorable Supreme Court. Again, the same points were raised, and the Honorable Supreme Court refused to interfere and refused to entertain those points and practically rejected those points. And I'm saying no. And for that purpose, I need to point out first, my lord, the statement in paragraph 45 of the judgment, which your lordship will find it running page 1238, my lord. Paragraph 45.
Where was that? The rejoinder one, yes. Page?
Page 1238. The memo paper now. This is the rejoinder filed by them in IA 3216 of 2025. Page 1238, as your lordship got, my lord.
Rejoinder, which one? Against the respondent 2?
Respond number 2.
2.
One which was referred by my learned senior, my lord, the same bunch.
Paragraph 45. Okay.
Paragraph 45.
28, paragraph 45.
1238 page number.
Starts from 1223.
Part of the order passed by Honorable Justice Midul Kalita, against which we went to Honorable Supreme Court, my lord. And my lord, this was an order passed on an application under 151 because in the first appeal before the Supreme Court, there was an interlocutory application under order 39(1) and 2. There, before the appeal is finally decided, an interim order was passed not to transfer. And then there was a transfer. And in that event, they said there was a violation of the order passed by the Supreme Court. So kindly retransfer it. And that application was under 151. And in that case, this is the observation at paragraph 45, which becomes relevant now. Since the applicant has also filed another application, interlocutory application, IA number so and so, under Order 39 Rule 2A of the Civil Procedure Code, the plea of respondent number 2 that as per the bylaws and rules of NSDL, the phrase transmission of security and transfer of security carries different meanings may be examined in the said interlocutory application. So this on the court is not decided, which is pending. However, as apparently it appears that the respondent number 2 in her request made on 7/11/2025 to respondent number 3 had suppressed the order dated 24/9/2025. That was the interim order, my lord. This court is of considered opinion that even the process of transmission of the aforesaid shares from DPID number so and so to DPID number so and so would amount to a transfer in violation of the restraint order dated 24/9/2025 passed by this court in I number so and so. Then, my lord, the last paragraph 47, next page, lordship will kindly see. Para 47 at the next page, my lord. Under the circumstances discussed in the foregoing paragraphs, this court is of considered opinion that until the IA civil number so and so under Order 39 Rule 2A of the Code of Civil Procedure is decided, this court is bound to set the wrong right, which is apparent from records. So only for the purpose of setting the wrong, according to the court, my lord, right, this order was passed, and no such order was passed on merit. Then when we took the matter to the Honorable Supreme Court, my lord, lordship will find what was the order passed by the Honorable Supreme Court, which will lordship find in same volume, my lord, page 1320. While we were not inclined to interfere with the impugned order passed by the High Court, we direct that the FAO and the suit shall be decided expeditiously. Needless to say that the observations made in the impugned order will have no bearing on the subsequent proceeding, meaning thereby the observations, if any, on which reliance is sought to be placed today, that some observations were there, this court did not interfere, on the Supreme Court upheld it. There is nothing which will deter your lordship to pass a fresh order and examining the matter afresh and passing an order as your lordship pleases, based on the submissions by both the parties. So, my lord, this I am pointing out for the purpose of meeting the argument made by my learned friend that all these points were raised, these were negated, all of the Supreme Court affirmed, so there is nothing new to be again considered. That is absolutely, my lord, untenable. Now, my lord, lordship will, my lord, although I am at the cost of repetition, my lord, submitting that I have no intention to sell those shares. And that is why I am saying that even if there is an interim prayer which they have made is granted, I have got no difficulty, my lord. But it appears that they are not satisfied with the kind of prayer they have made in the temporary injunction application. What they want, rather, is that initially there was a status quo order. And that was an ad interim, your lordship is aware, my lord, before a temporary injunction application is finally decided, at times in order to protect the plaintiff, an ad interim temporary injunction order is passed. And more often than not, it is in the form of a status quo, which is, my lord, has been described by the Honorable Supreme Court and also by the High Court at times is very vague, and it leads to different types of consequences. And if it is a immovable property, either land or building, a status quo order is passed, it protects the interest of the plaintiff to maintain the status of the subject matter of the suit. But here is a case, my lord, where there is a question of two things, my lord, transmission and transfer. their suit is for what matter? Their suit is that the plaintiff father filed the suit against the daughter, praying for a declaration that, see, although the shares are lying in the joint account, I am the owner of the shares. So he prayed for a decree before the trial court that kindly declared that I am the owner of these shares, although it is lying in the joint account. Then, till the matter is finally decided in course of trial of the suit, my lord, and the evidence is recorded, there was an apprehension that if, I'll go to the specific paragraphs of the plaint, my lord, the NSDL bylaws, which are statutory in nature, provide that in the case of a death of a joint holder, the shares will be automatically, by operation of law, there is a difference between transfer and transmission. They are avoiding this distinction because for the simple reason that moment the statutory bylaws of the NSDL, my lord, are taken into consideration and transmission is allowed, I will be entitled to enjoy the benefits of shareholding. I'll be able to participate in the meeting. Their prayer in the suit, their decree they prayed for in the seat is not for deterring me or preventing me from enjoying the fruits of the shares. Their prayer, their whole apprehension of the father for filing the suit was that I should not transfer it to the third party till the suit is finally decided. Now they have taken advantage of the status quo order for 12 years, my lord. And what was their conduct during these 12 years? This honorable court has, in the earlier round of litigation, has recorded, I'll come to that also, how they have enjoyed the status quo order and how they have utilized the status quo order in preventing the present, my lord, respondent from participating in the meeting and enjoying other benefits attached to the shareholding, although I am a joint holder. And that is why they want a status quo order, not a order which they have prayed. Now the question will be, your lordship is now called upon to decide whether that transmission of share from the joint account to the surviving joint holder can be prevented in a suit of this nature during the pendency of the suit. Transfer is a different thing. Transfer, I am conceding that I will not transfer. Let there be an order of temporary injunction. But they are not satisfied with that. What they want is, by taking advantage of some order to be passed by the court, now there is no status quo order. Now what they want is, by virtue of some order, in a way different from the order they have prayed for in the temporary injunction, they want to deprive me of my right as a joint holder. Now I'll have to project before your lordship what is the right of a joint holder, number one, and number two, is there under the Companies Act and the NSDL rules, which is a statutory rule because that has been framed in exercise of power conferred by the Depositories Act, which is a central act, my lord. These rules and the provisions of section 56 and other sections of the Companies Act, I'll point out, my lord, provide that in the event of death of a joint holder, transmission will be by operation of law, which now they are trying to prevent. They do not come forward with the specific provisions of the Companies Act because it is by operation of law. And this is one of the grounds on which their prayer was rejected by the learned trial court. So far as transfer is concerned, my lord, transmission takes place by operation of law because if immediately after the death of a joint holder, on moment the intimation is given to the depository participant, the transmission has to take place by operation of law. Whereas transfer of share takes place on the basis of an instrument of transfer. Until and unless there is an instrument of transfer, the shares cannot be sold to any third party, my lord. Now, the question is, during the pendency of the trial of the suit, my lord, whether the plaintiff can prevent transmission of share from the joint holding to the surviving holder. That is the only question to be decided by the Honorable Court. Because what they want indirectly is there should be a vague order based on which they can enjoy and they can prevent me particularly from participating in the board meeting. My lord, last 12 years, they have prevented me from participating in the board proceedings, and they have taken decisions on their own by depriving him from participating in the meeting. Now, Lordship may kindly see the plaint. It starts from page 28 of the, Lordship may now kindly take the memo of appeal, my lord, filed by them, FAO 62 of 2025. My lord, I'm referring to the plaint at page 28, and relevant paragraph I'm referring is paragraph 33 at page 37. The memo of appeal, my lord. FAO 60, FAO, my lord.
Appeal to, I don't know, to IA. To IA.
Turn to page 37 straight way.
Yes.
Paragraph 33 at the bottom.
Huh?
Paragraph 33 at the bottom. my lord.
Page 20,
37.
37. Yes, para 33.
Paragraph 30. This is the part of the plaint. That under the NSDL rules, the plaintiff himself is saying that under the NSDL rules
Yes.
and bylaws, and more particularly rule so and so, in case of death of one holder, one of the holders in a joint demat account, shares can be moved to another demat account solely in the name of the surviving holder, merely on receipt of the application in the form specified in Annexure O, along with a copy of the death certificate duly attested by the notary public or by a gazetted officer, along with a copy of the death certificate of the deceased holder. Para 34 is also relevant, my lord. That the plaintiff reasonably believes that upon the death of the plaintiff, the defendant number 2 will act with immediate, undue haste and submit necessary documents to the defendant number 3 for moving the shares into the demat account in her sole name, and nothing will thereafter stop the defendant number 2 from disposing of the shares in any manner she likes. My lord, these are the two paragraphs based on which the plaintiff had to rush to the civil court for getting a decree. Let's see. Under the extent act they have not mentioned, I'll mention, my lord, and the NSDL rules and bylaws. In a joint account, moment one of the account holder dies, it is by operation of law that there will be a transmission of shares in the name of the surviving joint holder, and thereafter nothing will stop him from disposing of the shares. So there is an apprehension of sale, transfer of share by me. And it is in this context, and my lordship will just see why this apprehension came, because of the statements made in paragraph 24 and 25, which your lordship will find at page 34, my lord. There are 24 and 25 at page 34, my lord. That on 22nd of August 2011, the plaintiff again requested defendant number 2 to sign the delivery instruction slip of defendant number 3. The interdepository delivery instruction issue slip of defendant number 3 was also sent to defendant number 2 by courier on so and so. The defendant number 2, however, refused to sign the interdepository delivery instruction issue slip. While sending the issue slip, the plaintiff through inadvertence sent the entire so-and-so booklet containing the said issue slip along with 10 delivery instructions numbering so-and-so. Defendant number 2 is illegally and wrongfully withholding the entire booklet containing the said issue slip along with 10 delivery instructions number so-and-so, as the defendant number 2 has no right to the same. That on 1st of September 2011, a letter was sent by the plaintiff requesting defendant number 2 to sign the inter-depository delivery instructions issue slip sent to her on so-and-so. The defendant number 2 has failed to respond to such request. Plaintiff also appears that said entire TIDF DIS booklet containing said issue slip along with 10 delivery instructions numbering so-and-so may be misused and or used against the interest of the plaintiff. You know, these delivery instructions are necessary to be signed in a joint account holding by both of them. I will show documents, my lord. HDFC said will not do it subsequently unless both of them sign. So she approached the court and said, "They see those documents are delivery instructions are lying. I have signed. Moment she signs and submits there will be a transmission into her account, a single account, individual account, and from there she may sell." That was the imprehension with which the plaintiff approached the civil court. Now, Lord, will kindly see what we are, my lord. This is not trial, my lord. Trial court will take care of the trial of the suit and pass a final decree, either allowing or dismissing the suit. But what was the prayer for temporary injunction, which your lordship will find here, my lord, in the same document at page 200 is the the temporary injunction application, my lord. In order to protect and preserve the subject matter, this application for temporary injunction was filed. Page 212 is the prayer portion, madam. Starts from page 200. Page 212 is the prayer portion, madam.
Yes.
In the plaintiff's aforesaid, it is therefore prayed that your honor would be pleased to pass an ad interim injunction restraining the opposite party number 2 to her servants, workmen, employees, and agents from causing any transfer in whatever nature in respect of 8,61,918 shares of BNA Limited lying with opposite party number 3 in its account bearing number so-and-so, and further restrain the opposite party number 2 from using delivery slips lying with opposite party number 2 bearing number so-and-so, and restrain or directing the opposite party number 3, that is the bank, my lord, not to transfer so-and-so shares of BNA Limited to in its account bearing number so-and-so and client number so-and-so, etc. The apprehension expressed in the temporary injunction petition is that moment this transmission takes place, it will go to her share, and thereafter nothing will prevent her from transferring those shares to a third party. Purpose of filing the suit and the prayer made in the temporary injunction is not aimed at getting a restraint order against the transmission, which is by operation of law. The whole purpose of filing the suit and the prayer made in the temporary injunction is to prevent me from transferring those shares by utilizing those delivery slips, etc., where he has already signed, plaintiff had already signed, from transmission, so that she is not allowed to sell it to a third party. Because during the pendency of the suit, it has to be protected. Third party right should not be created. I am also saying, my lord, before this on the course, that I am not intending to create any third party right. I do not want to transfer, I want to retain it. That is why your lordship may grant the temporary injunction. But it appears, my lord, they are not happy with that. They want an order beyond the pleading and beyond the prayer made in the temporary injunction petition. And now question is, my lord, whether that can be allowed, or in other words, my lord, whether the automatic transmission or transmission by operation of law from the joint account to the individual account of the defendant number 2 can be prevented by way of this temporary injunction. My lord, just I am pointing out that the learned trial court did not commit any error in rejecting their prayer, which will be evident from just 2-3 paragraphs from the order passed by the learned trial court, my lord, which your lordship will find in the volume C of this memo of appeal at page 1156, my lord. In the memo of appeal, there is a volume C, my lord.
Volume C.
Volume C. Memo.
This is volume B.
It is not in. My lord, possibly I am wrong. This is volume C of the reply filed. It's our reply.
What do you want now?
Now, I want to point out the impugned order. my lord.
Which volume? Which volume?
Here, it is in this volume C, my lord. Our written up, 380.
Written objection to the stay application.
Yes, it is written objection to the stay application, my lord. Memo of appeals. My lord, it is there in the memo of appeal also.
Okay, point out from there now.
Yes. Here in the memo of appeal. 412. Volume B, my lord. Volume B of this FAO, my lord.
Yes.
Part of appeal, my lord. Page 412. 412, my lord, starts.
Yes. Yes.
Yes. My lord, it is internal. 419. Page 419, my lord. Running page 419, there are. Your lord will kindly turn to the previous page 418. From there I'll read para 14. Para 14. Page 418. And the learned trial court has passed absolutely reasonable order, madam. Para 14, madam. Considering the materials as well as submission of learned counsel for both sides, it appears that petitioner side is the joint owner of so-and-so number of shares in the OP number 2. It is also seen from the pleadings of the petitioner that even on request by the petitioner, OP number 3 refused to accept delivery instructions on the ground that signature of second holder, that is OP number 2, was missing. Thus, under the given circumstance, it appears that one of the joint holders of the account alone cannot transfer the share. There are apprehensions there is a transfer. Now, the learned trial court is saying that unless HDFC has refused to transfer, unless both of them sign. At that time, my lord, that was the position. At the time of filing of this petition under Order 39, Rule 1 and 2 of the CPC, both the joint account holders were alive. Thus, cause of action for filing this petition for restraining OP number 2 from transferring the shares had not arisen at the time of filing the petition. In other words, the petitioner did not have prima facie case at the time of filing the petition. During the pendency of this media case, the original petitioner, H.P. Barua, who was one of the joint account holders, had expired. Accordingly, as per rules so-and-so of the NSDL rules and bylaws, the OP number 2 was empowered to transfer the said shares to another demat account in her name. In exercise of powers conferred under Section 26 of the Depositories Act 1996, National Securities Depository Limited makes the NSDL bylaws which have been approved by the Securities and Exchange Board of India, SEBI, pursuant to order number so-and-so dated so-and-so of SEBI board. NSDL operates under the Depositories Act 1996 and is regulated by SEBI, meaning its rules and bylaws have statutory backing. The principle of the rule of law ensures that all actions and decisions, including those of judiciary, must adhere to existing legal framework. A court cannot arbitrarily issue an order that contradicts established laws or regulations. Thus, while court has the authority to issue orders, it must do so within the established legal framework, which includes Depositories Act and the rules and regulations framed under it. In the case in hand, where NSDL rules has clearly empowered the surviving holder of the demat account to transfer the shares to another account in her name, there is no scope of restraining her in direct contravention of the express rule. Thus, seeking remedy against an established legal position in this fact, skeptic court cannot be termed as existence of a prima facie case. And then, my lord, paragraph 20 at the bottom, it becomes relevant, my lord. It is submitted that the said shares were paid up and purchased by the petitioner alone and only for the purpose of administrative convenience of OP number 2 was taken as joint account owner of the said shares, the said facts will come on trial. Another important fact as noticed from the pleadings of the petitioner is that the 947289 number of shares which were bequeathed to the trust were not transferred to the joint account of the original petitioner with OP number 2. The shares which were maintained in a separate account of the petitioner in ICICI Bank were only transferred to that joint account. OP number 2 is one of the children of the original petitioner. Other children of the legal heirs have not challenged the right to so and so. As the shares are not the trust properties, I hold that balance of convenience also doesn't lie in favor of the present petitioner. Lordship has seen, my lord, the Lionel trial court has taken into consideration two things. One, let's see, under the statute and the statutory rules framed in exercise of power conferred by the Depositories Act, it is by operation of law that transmission should be allowed to one of the surviving holders after the death of one of the joint holders. And the court says that I cannot go beyond the act and the rules framed thereunder, which are statutory in nature. And you are asking for an order of injunction whereby I have to travel and go beyond the act and the rules framed thereunder. This I cannot do. And it is by operation of law that after the death of a joint holder, the share will be transmitted in the name of the surviving holder. Where is the illegality, my lord, in this order? Absolutely no illegality in the order. And the appeal has been filed not for the purpose of getting a temporary injunction which they have prayed, which I am conceding, which we are conceding. The appeal has been prepared with a prayer that Lordship will pass some order based on which this transmission, which is to take place by operation of law, during the pendency of the suit, I should be prevented from enjoying the shares and the benefit of the provision of law, which says that in a joint account holding, if one of the joint holders dies, then there should be an automatic transmission of shares only after the intimation is given. I'll come to the relevant provisions of the Act now, my lord. Lordship may kindly permit me to section 66 of the Companies Act first. My lord, a submission has been repeatedly made that there is no distinction between transmission and transfer. And we are the second holder. Our status is sought to be relegated to the status of a second holder, meaning thereby that first holder is everything, second holder is nothing. But the Companies Act and the relevant rules and bylaws do not make any distinction between the first holder and second holder. There is no concept like this, my lord. It is a joint holding. It is only because of the convenience that name of the first person is written on top, the name of the second, there may be 10 joint holders, my lord. And if these names of these persons are mentioned serially in a, my lord, raw or in a seriatim, one cannot say that you are the 10th holder and you have got no right. 9th holder has got a better right than the 10th. There is no concept like first holding and second holding. I will just show, my lord. My lord, depository participant which maintains the account, my lord, also does not recognize such difference. I will come to that, my lord. Lordship may kindly see for section 56 of the Transfer Companies Act 2013, my lord. Well, we are trying to resist their prayer by relying on these provisions. These provisions were not referred to by the appellant before your lordship. I'm referring them. Section 56 says transfer and transmission of securities. Lordship has got a copy of the Companies Act.
Yes.
A company shall not register a transfer of securities of a company or the interest of a member in the company in the case of a company having no share capital other than the transfer between persons both of whose names are entered as holders of beneficial interest in the records of a depository unless a proper, this is important, unless a proper instrument of transfer in such form as may be prescribed duly stamped, dated and executed by or on behalf of the transferor and the transferee and specifying the name, address, occupation if any of the transferee has been delivered to the company by the transferor or the transferee within a period of 60 days from the date of execution along with the certificate relating to securities, or if no such certificate is in existence along with the letter of allotment of securities, provided that where the instrument of transfer has been lost or the instrument of transfer has not been delivered within the period prescribed, the company may register the transfer on such terms as to identify as to indemnity as the board may think fit. Now this is important. Subsection 2 is more important. Nothing in subsection 1 shall prejudice the power of the company to register on receipt of an intimation of transmission of any right to securities by operation of law from one person to whom such right has been transmitted. Now, Lordship will see where from this operation of law comes. It will be yes. Now, my Lordship may see kindly section 58, my Lord.
Yes.
Section 58, my Lord. Refusal of registration and appeal against refusal. If a private company limited by shares refuses, whether in pursuance of any power of the company under its articles or otherwise, to register the transfer of or the transmission by operation of law of the right to any securities or interest of a member in the company, it shall within a period of 30 days from the date on which the instrument of transfer or the intimation of such transmission, as the case may be, was delivered to the company, send notice of the refusal to transfer and the transferee or to person giving intimation of such transmission, as the case may be, giving reasons for such refusal. So this provision makes it further clear that there is a clear distinction between transfer by operation of law and transmission. Then if your Lordship kindly goes to the same.
One is by operation of law, other is by an instrument, but the net result is the same, is it not?
No, my lord.
Same rights are conferred on the transferee or the.
My lord. Supposing there is a joint holding, A and B jointly holds. A dies. Then, since it was in a joint account, it has to be transferred to the individual, transmitted to the individual account of the surviving member. But this is not transfer. Transfer is sale of, this is not sale, my lord. Sale to a third party can be done only by an instrument of transfer. If that joint holder.
If that is so, then the second holder or by whatever name called would have no right to transfer that part of the share to any third person.
If there is injunction.
No, even if there is no injunction. If you say that by operation of law, transmission is different from transfer. Transmission does not confer the same rights as a transfer. Then in that case, the person to whom the transmission takes place has no right to transfer it to a third party.
They have got a right by an instrument of transfer. My lord, this
How? First, the right has to be vested in the person to whom it is transferred.
That's what, my lord. Supposing, that's why I am giving the example. If there are joint account holding and there are A and B. Now A dies. It has to be by operation of law under this act and the rules. I'll show to the rules also, my lord. This transmission will take place from the joint account to him. Now he is the individual owner. Yes. But this is not transfer. If he wants to transfer to a third party, there has to be an instrument of transfer. And so
that is all right. So you have the power after the death of one of the holders, after the shares are transmitted to you,
I have the power.
according to you, you have the power to transfer it to a third person by an instrument.
Yes.
So that means the same power is vested in you, whether it is by way of a transfer or by way of a transmission. Ownership.
Possibly I will be able to.
If you do not have the ownership of the shares,
My lord.
then how do you transfer it by way of an instrument?
That is what, my lord, transmission has to take place because transmission is by operational flow. Moment a person dies, intimation is given. The depository participant in which company, my lord, the accounts are maintained in digital form nowadays. Earlier used to be a paper, my lord,
Yes.
certificate. Now it is in digital form. They will record that now it is only in the name of the surviving joint holder. Thereafter, if the surviving survivor of the joint holder wants to transfer it to any other person, then there has to be an instrument of transfer.
That we understand.
Yes.
But you please answer this question,
My lord.
whether transmission and transfer
Yes.
confers different rights on the beneficiaries or the same rights.
Transfer and transmission is totally different, my lord.
Yeah, two are different because they operate under different circumstances.
Yes, my lord.
One operates on the death of a joint account holder.
Yes.
And the other operates on the basis of an instrument when
Absolutely.
both are alive.
Yes.
I may transfer it to you, we are
Yes.
account holders, by way of an instrument, I transfer it to you.
Yes.
But under both circumstances, you gain the same power and rights over those shares.
My
Is
lord,
it not?
My lord, if it is a transmission only from joint to one of the surviving, then it remains within the two persons. Now, for a transfer to a third person, it is transferred by an instrument. I am again giving another example. If supposing there is only one person, there is no question of any transmission because
What would, in that case, what would be the status of the legal heir of the deceased account holder?
yes, my lord, your lordship is absolutely correct. Supposing there your lordship is absolutely correct, my lord. I am wrong rather. If it is in the name of A only, individual account, he dies, from him to his legal heir is a transmission. From him to his legal heir is a transmission by operation of law. Your lordship is absolutely correct. But from him to a third person, new person, is a transfer which has to be done by instrument of transfer.
No, to the legal heir, if it is a transmission to the legal heir,
My lord.
then how is it, can there be a simultaneous transmission to the surviving account holder?
No, my lord. If it is joint only, when a transmission in favor of the surviving joint holder, I am coming to that NSDL rules, my lord. That will make the clear, my lord. And copy the TV. Transmission security that you have. My lord, may kindly go to page 51, my lord. At the bottom page numbers are given. My lord, make this situation clear, my lord.
NSDL bylaws,
My lord.
page 51.
My lord, I'm just. Yes. My lord, may I kindly turn to page 51.
Transmission of securities.
Yes. My lord, before that, I just wanted to actually point out, lordship may just see after the contents, it is mentioned short title and commencement. Just see fourth page, my lord.
Yes.
Left hand side, short title and commencement. In exercise of powers conferred under section 26 of the Depositories Act 1996, National Securities Depository Limited hereby makes the following bylaws, which have been approved by the Securities and Exchange Board of India pursuant to order number so and so dated 5th October 1996 of Securities and Exchange Board of India. These bylaws may be called the bylaws and National Securities Depository Limited, that is NSDL, my lord. This is the statutory force of this bylaws. Now I am referring to the specific provision on page 51 at the bottom. On top, lordship will find 9.10,
Yeah.
transmission of securities. 9.10.1, NSDL shall effect transmission of securities balances of any client due to death, lunacy, bankruptcy, insolvency, or by any other lawful means other than transfer. That means transfer is different. Other than transfer, it is transmission. Then next one, my lord, 9.10.2. In case where the deceased was one of the joint holders in the client account, the surviving client shall be the person recognized by NSDL as having any title to the security balances in that joint client account. It says that if it was lying in the name of father and daughter, moment the father dies, the NSDL will recognize only the surviving joint holder. This is transmission, my lord. And for the sole, my
Recognize
lord,
as having title to the security balances.
Yes.
That means ownership.
yes,
Yes, that is what we are saying.
my lord, yes.
You were saying no.
No, my lord. My lord, what I am saying is, my lord, by way of operation of law of transmission,
In
it
essence,
becomes owner.
Mr. Majumdar, in essence, what you are saying is that transmission does not result in any transfer of power to the transferee, but the transferee has the power to sell the same by way of an instrument.
Differently, my lord. What
That was,
I was
that is what logically follows from your submissions just made.
No, man.
Yes.
I'll clarify once again. My lord, when there is a joint account, joint account, both of them are owner. I am referring to transmission only to show that if one of them dies, what happens? Only for the purpose of showing that if one of them dies, what happens, whether it is, this transmission is automatic or not. Otherwise also legally, my lord, otherwise normally also, if a property is held by two persons, one person dies, it goes to the second person. No. They were holding jointly. Similar is the case here, my lord. This transmission from one joint holder to another joint holder is transmission, and this is distinct from transfer, because transfer means by an instrument of transfer, you are selling it out. Cool. My lord, the lordship may kindly see this 9.10.3 also. It is in the case of a sole holding, single holding. In case where the deceased was a sole holder of the client account, his legal heirs or legal representatives shall be the only person recognized by NSDL as having any title to security balances in that sole client account. This is the position, my lord. So now, my lord, that is why, my lord, our submission is, so far as transmission to the surviving member of the joint holding is concerned, that is by operation of law, moment an intimation is given, even the plaintiff is aware of that. My plaintiff is mentioned in the plaint that under the NSDL rules. Now, what I am submitting before your lordship is whether by an application for temporary injunction, this
Statutory provisions can be.
yes, my lord, this transmission can be prevented, because what ultimately intended by the plaintiff is that there should not be any transmission. This should lie in the account of the wherever it was. Now the person is dead, and the joint account should remain there, so that unless the transmission takes place, I cannot participate in the board meetings, whether it can be allowed or not. Now, a second question will come, my lord. Supposing today I am prevented from participating in the board meetings because of my right under the NSDL rules and the Companies Act, that on the death of the one of the two joint holders, I am entitled to transmission. This is not transfer, it's not transmission, it comes to me. Now it has to automatically come to me. Now, if it comes to me, I enjoy the benefits of those shareholding. I participate in the board meeting. I get my dividend, my lord. They have somehow succeeded in obtaining an order that I should not be given the dividend, although I am joint holder and I was entitled to the transmission. And once transmission takes place, I am the owner. Whether I can be prevented during the pendency of the suit is the question before your lordship. What is the status of the plaintiff and what is the status of this joint holder, surviving joint holder? Can the plaintiff, father is expired, plaintiff has now got substituted only on the basis of a will. My lord, this Honorable Court in the earlier round of litigation has taken into consideration the judgment of Pinapani, which says that based on a will, you can be substituted. Decree also may be passed but you cannot enforce the decree until and unless the probate is granted. And the probate petition is pending. Now, last 10 to 12 years, probate petition has been pending. They are the applicant. Now, what was their conduct? This honorable court has taken into consideration. I will just point out one paragraph from there. What was their conduct? Whether they were diligent enough to get the early disposal, or whether they were enjoying the benefit of the status quo order initially passed, and thereafter, because of the death of the father, my lord plaintiff, suit was kept in abeyance. Substitution did not take place. And because of the nature of order passed, which is quite vague, that is status quo, they have prevented us from participating in the board meeting. Whether this can be allowed today. That is the question your lordship will kindly decide, madam. Oh, he definitely could be. Well, for that, just one paragraph I'm showing, if your lordship permits me. This is in respect of their conduct in utilizing the status quo order so far, my lord, which they are even now praying, which that your lordship will find at page 1121 of that volume C, my lord, which I earlier pointed out.
Volume C of our objection in 3216.
3216. Is 1133 and just two paragraphs I'll point out.
Page
one
of the appeal.
This is that volume C. I objection 321.
Volume C2.
Nothing I can see from here.
এইটো ভলিউম চি নহয় তো
110.
এইমাত্ৰ ওলাইছিলে যে ভলিউম চি এটা তাতে থৈ দিয়া আছে Yes, you can read.
Para 22. This court, during the course of hearing, raised a specific query upon the learned counsel who appeared on behalf of the opposite party number 3 as to whether he had any objection in allowing the substitution application, thereby substituting the opposite party number 3 against the deceased plaintiff, which was the opposite party number 3's prayer in the petition number so-and-so as well as CRP number so-and-so. The learned senior counsel appearing on behalf of the opposite party number 3 did not provide any straightforward answer. Opposite party number 3 is the appellant before your lordship today, my lord. Has your lordship got, my lord?
1133.
Yes, my lord. Towards the end, my lord, the learned senior counsel appearing on behalf of the opposite party number 3 did not provide any straightforward answer, but rather stated that he wished that the probate proceedings be disposed of by the learned High Court of Calcutta at an early date. This is one. And then just one more paragraph at page 1150.
One 150.
This is, it is actually paragraph 41, starting from page 1149. I am reading only the relevant portion, madam. Page 1150. Lordship has got, madam.
Yes.
Towards the end, Lordship will find the only logical conclusion that can be reached is that the opposite party number 3, that is the appellant before Lordship, madam, would have no right to substitute, and consequently the suit proceedings would stand abated. It appears to this court that the said submission made by the learned senior counsel for the opposite party number 3 not only goes counter to the interest of the opposite party number 3, but also seems to be a desperate attempt to keep the suit proceedings in abeyance indefinitely, and in the meantime, the ex parte injunction order be continued. That is the status quo, madam. This is the fallout of the status quo order passed by the learned trial court initially in 2012, which they were enjoying. Because that was the, my lord, weapon based on which I was deprived of all my rights as a joint shareholder. Although by operation of law, automatically soon after the intimation is given, the my lord depository participant should have recorded. And this keeping evidence order of the trial court, my lord, was lifted at our instance. We had to file an application before this court to recall an order passed at least 4 or 5 years ago, my lord. 10 years ago. We filed an application to recall that order. We filed, my lord. They are the plaintiff. And we went to the extent of conceding their prayer for substitution based on the will, so that the suit can proceed. They were not interested that the suit should proceed, nor were they interested in the disposal of the probate petition before the Calcutta High Court. This is the conduct of the appellant before your lordship. I am just pointing out. Companies share capital debenture rule the
Yes.
my lord. Yes, share capital debenture rules. My lord, I am just pointing out rule 11 of the company's share capital and debenture rules 2014.
It is there in this book, Companies Act.
This is only to support my submission that the transfer is different from transmission and transfer takes place in a different manner, my lord. My lordship may kindly see rule 11, my lord. Page nation, my lord, there is no page nation. I am very sorry, my lord. We could have done it. Rule 11 provides for instrument of transfer, my lord.
Yes.
An instrument of transfer of securities held in physical form shall be in form so and so, and every instrument of transfer which with the date of its execution specified thereon shall be delivered to the company within 60 days from the date of such execution. In the case of a company not having share capital, provisions of sub-rule 1 shall apply as if the references therein to securities were references listed to the interest of the member in the company. A company shall not register a transfer of partly paid shares unless the company has given a notice, etc. So, well, the instrument of transfer is different from transmission. This is transmission takes place to the surviving joint holder only after immediately the intimation of death of the one of the joint holders is given. On a complete act of department. Only one thing I'll be failing in my duty to point out to your lordship that in the Companies Act also there is a provision. But this endeavor I am making, and I am taking your lordship's time to basically distinguish between transmission of shares and transfer of shares, which they have been opposing from day one. That there is no difference. All are transfers. My lord, in the Companies Act, my lord, 2013, at page 289, what we will find the table F.
Page?
Page 8-9, my lord. If it is same book, page numbers will tell you, my lord.
Yes.
Table F. There is a flag possible.
Section 466 rather.
Schedule 1, table F.
Schedule 1, table F.
Schedule 1.
No, table F, man, on top.
Apply for.
And we'll find out for lots of kindly hand over to them.
Yes, table F.
Yes. Table F, articles of association of a company limited by shares. Now, if your lordship turns to page 2, the next 2 pages, my lord, page 291 in this book, my lord. clause 19
Yes.
is under the caption transfer of shares. What we have seen, manner.
Yes.
19.1, the instrument of transfer of any share in the company shall be executed by or on behalf of both the transferor and the transferee. And then next page, my lord, there is another caption, transmission of shares. (23.1) On the death of a member, the survivor or survivors where the member was a joint holder and his nominee or nominees or legal representatives where he was a sole holder shall be the only persons recognized by the company as having any title to his interest in the shares. So, my lord, what I am trying to impress upon your lordship is the Companies Act and the NSDL rules and bylaws, the articles that is under articles of association of the in this Companies Act, my lord, provide that in the case of a joint holding, in the case of death of one of the joint holders, the surviving holder becomes the person in whose name the transmission has to take place by operation of law. And what is now sought to be done is to prevent this transmission. Whereas their apprehension, based on which they have filed the suit and the prayed for a temporary injunction, is that during the pendency of this suit, you should not take any step by which ultimately, if the suit is decreed, they are not deprived of their benefit of the decree to be passed. Because if I transfer it to a third party, my lord, if the decree is passed in their favor, they will not get anything. That is why there is a necessity of protecting the subject matter during the pendency of the suit. If the transmission takes place, this protection will continue. I will not sell it to third person. Moment the decree is passed, it goes to the plaintiff because I am a defendant. So these being the position, my lord, my submission before lordship is that I have repeated, I will not repeat, that I am not opposing their prayer for a temporary injunction restraining me from transferring those shares. But so far as transmission is concerned, that being a different, that being by operation of law, they cannot prevent it because they want to prevent it because they want to deprive during the pendency of the suit. And what is the status of the plaintiff? You are yet to get a decree. Now you want to enjoy the benefit which they have been doing till now. They are yet to get a decree, yet to get the probate petition in the pending in the Calcutta High Court, my lord. They are enjoying the benefit of the shares, and I am the joint holder. And the law says that in the event of death of one of the joint holders, the shares should have been automatically transferred by operation of law in my name, and I should have been the person who will enjoy the benefits of the shares. Now, my lord, a few 2-3 judgments when I am citing. First, I am relying on a judgment of National Company Law Appellate Tribunal, Mayor, NCLAT, reported in 2023 SEC Online and CLAT 648. More or less same nature of facts, Mayor. I'll straightly go to para 19, Mayor. Para 19, Mayor. मुझे लॉटरी बोल रहा है पैरा 19
Yes. Yes.
Para 19, I'm reading. Subsection 2 of Section 56 of the Companies Act 1956, which is extracted above, provides that the company shall have the power to register on receipt of an intimation of transmission of any right to securities by operation of law from any person to whom such right has been transmitted, we note that the term transmission has been distinguished from the term transfer of securities in section 56 of the Companies Act 2013. The import of the word transmission is that when legal right accrues to any person regarding securities of a company by operation of law, such persons can file an intimation with the company in accordance with subsection 2 of section 56 of the Companies Act 2013 for transmission of such securities shares in his or her name. Para 20, madam. The present case is a case of transmission of shares to the daughter of a deceased C. So-and-so, as is clear and evident from the letter of intimation dated so-and-so, sent by so-and-so to the company. Clause C of subsection 4 of section 56 stipulates that within 1 month from the date of receipt of intimation of transmission, the company shall deliver the certificate of relevant securities to the concerned person. We further notice from the reply dated so-and-so sent by the company through its authorized signatory that rather than considering the intimation to be for transmission of such shares, the company goes on a completely different track and states in reply that Kashvi's Parashar is not entitled for transfer of shares belonging to so-and-so of the company in view of last will of so-and-so. The reply further goes on to discuss the various clauses of the will and infers and states that Kashvi Parashar is only entitled to receive the value of such shares and therefore not entitled to transmission of said shares. Furthermore, the reply states that Kashvi Parashar is being paid a sum of rupees so-and-so per month from 2 months from the date of so-and-so. The reply of the company is to refuse the request for transmission permission of shares of a species and legally unsustainable plea, and so the company asks Kashvi Parashar to withdraw the intimation letter as she is not entitled for transfer of shares as per the last will of so-and-so. The learned counsel of the appellants had emphasized on the condition regarding sale of said shares back to the company, which is included in last will of Sri Gagan Parashar. To claim that Kashvi Parashar is not entitled to transmission or transfer of the said shares. On the matter of transmission of shares, we notice that section 56(2) of the Companies Act 2013 stipulates that upon receipt of an intimation, transmission of any right to securities by operation of law, the company is required to register the said shares in the name of the person conveying the intimation. It is clear that section 56 of the Companies Act makes a difference between in the name of the person conveying the intimation. It is clear that section 56 It is clear that section 56 of the Companies Act makes a difference between transfer and transmission of securities, and the present case is a case of transmission of securities. We are also of the view that there was no need for the company to have interpreted or acted upon the provisions included in the will of the Sri Gagan Parashar, since the intimation under section 56 of the Companies Act was merely about transmission of the said shares and not about execution of the so-and-so's will. In such a situation, it was not only undesirable but also unlawful for the company to have refused transmission of said shares when other class 1 legal heirs of so-and-so had given explicit no objection for transmission of said shares in favor of so-and-so. These no objections were submitted by Kashvi Parashar along with letter of intimation to the appellant company. And then, my lord, at the bottom, paragraph 25 is relevant. In the light of the discussion detailed earlier, we come to the conclusion that company was wrong in sending letter dated so-and-so to Kashvi Parashar. We are of opinion that on the basis of the material available and as required under law, the company should have transmitted the said shares in the name of Kashvi Parashar without getting into the issue of execution of the will or examining any settlement. The point in the last will of the so-and-so that interest of a third party has been created vis-a-vis the Kashvi Parashar would be a matter to be decided by the court of appropriate jurisdiction and therefore not an issue to be decided by the NCLT when considering case of transmission of shares. This judgment, my lord, in my humble opinion, clinches the issue as to whether transmission is automatic and only upon an intimation being sent, and whether the company is bound to transmit those shares in the name of the surviving joint holder. And in this case, as your lordship has seen, on the basis of a will, it was sought to be resisted. Same is the case here. They have got a will. Based on that, they were trying to resist. The court says no. Tribunal, this is the appellate tribunal's order. Transmission is different, it is automatic. Your will, if you have got anything, that's a different issue altogether. Now, my lord, on the matter of temporary injunction, tape to the again.
Where was husband? If you
My 2000. 2023 SCC online SC 177 Thiru K Palaniswamy versus M Shanmugam. Para 194. 177. Para 190. Para 73. This judgment of the Honorable Supreme Court I am relying for the proposition that manner. At the initial stage when you lost
2023 SCC online 177, this one.
yes, ma'am.
Palaniswamy.
Yes,
Yes. Para?
para 73, madam.
Yes.
When I read the judgment first, then I make my submissions. Apart from the above, we may also take note of the principle in relation to the matters concerning grant of interim relief, which have been stated and re-emphasized by this court in exercise of, in the case of so-and-so, para 194 matter. In addition to the general principles for exercise of discretion as discussed herein before, a few features specific to the matters of interim relief need special mention. It is rather elementary that in the matters of grant of interim relief, satisfaction of the court only about existence of prima facie case in favor of the suitor is not enough. The other elements, that is balance of convenience and likelihood of irreparable injury, are not of empty formality and carry their own relevance. And while exercising its discretion in the matter of interim relief and adopting a particular course, the court needs to weigh the risk of injustice if ultimately the decision of a main matter runs counter to the course being adopted at the time of granting or refusing the interim relief. We may usefully refer to the relevant principles stated in the decision of Chancery Division in Films and so. The principal dilemma about the grant of interlocutory injunctions, whether prohibitory or mandatory, is that there is by definition a risk that the court may make the wrong decision in the sense of granting an injunction to a party who fails to establish his right at the trial or would fail if there was a trial, or alternatively, in failing to grant an injunction to a party who succeeds or would succeed at the trial. A fundamental principle is therefore that the court should take whichever course appears to carry the lower risk of injustice if it should turn out to have been wrong in the sense I have described. The guidelines for the grant of both kinds of interlocutory injunction are derived from the principles. Now then, my lord, this Torah cause etc. referred. So what I am why I'm citing this judgment, my lord. The Honorable Supreme Court says always there is a risk of ultimately doing injustice if the court is found to be wrong at the end of the trial. Today, your lordship, supposing, refuses injunction to them. And at the end of the trial, the suit is decreed. Some amount of injustice will be caused to the plaintiff because during the period of the suit was being tried, they were not granted any temporary injunction. Then the reverse case is, today your lordship grants a temporary injunction in their favor. And after 2 years, at the conclusion of the trial, lordship finds that the trial court dismisses the suit. There also there is a injustice caused to the party who was not given the favorable order at the interim stage. Now, that is why the Supreme Court says court has to weigh where the risk is more. Now, I am coming to the facts of this case. My lord, today, what is the position? The shares were in the joint account. One of them has died. Law says by operation of law, it has to be transmitted in the name of the surviving joint holder. And so that she can exercise her right during the pendency of the suit. Tomorrow, if the suit is decreed, thereafter, they will get the shares. Because the suit will be decreed that the plaintiff is the only owner of those shares. No prejudice will be caused to them if they are refused the temporary injunction today. And at the end of the trial, the suit is decreed. But today, your lordship prevents me from exercising my right by granting them an order of not to transmit also. And at the end of the trial, their suit is dismissed. Now, I have been deprived of my right to participate in the meetings of the board and also to get other benefits of as a shareholder, to get the dividend, etc. The parties, whatever decision the company takes during this period, this cannot be overturned if the decree is ultimately passed. So the risk is more here in granting the temporary injunction in favor of the plaintiff, petitioner, and appellant before lordship. This is my submission, and that is why it should not be granted. Then, my lord, there is one judgment which is very relevant. My lord, whether
So the only prejudice caused to you is non-participation in board meeting and certain other benefits of the shareholder, since you have undertaken not to transfer the same anywhere.
And one judgment may be relevant, that is Gujarat bottling of 1995, 5 SC, page 545. 1995, 5 SC, page 545, Gujarat Bottling Company Limited versus Coca-Cola Company and others. I am referring to paragraph 43, only one paragraph.
Paragraph.
Paragraph 43. Only one paragraph.
Yes.
The grant of an interlocutory injunction paragraph 43.
Yes.
The grant of an interlocutory injunction during the pendency of legal proceedings is a matter requiring exercise of discretion of the court. While exercising the discretion, the court applies the following tests: whether the plaintiff has a prima facie case, whether the balance of convenience is in favor of the plaintiff, and whether the plaintiff would suffer an irreparable injury if his prayer for the interlocutory injunction is disallowed. The decision whether or not to grant an interlocutory injunction has to be taken at a time when the existence of the legal right assailed by the plaintiff and its alleged violation are both contested and uncertain, and remain uncertain till they are established at the trial on evidence. Relief by way of interlocutory injunction is granted to mitigate the risk of injustice to the plaintiff during the pendency before that uncertainty could be resolved. The object of the interlocutory injunction is to protect the plaintiff against injury by violation of his right, for which he could not be adequately compensated if damages recoverable in the action if the uncertainty were resolved in his favor at the trial. Now, this is important matter for which I am relying on this paragraph. The need for such protection has, however, to be weighed against the corresponding need of the defendant to be protected against injury resulting from his having been prevented from exercising his own legal rights for which he could not be adequately compensated. Today I am prevented from participating in a board meeting. They take and last 14 years they have been doing so. Although there was no specific order, but taking advantage of that status quo order. That is why they repeatedly say that let there be a status quo order which was passed in the order. But here I'll pause for a moment and say that today your lordship is passing an order in the final adjudication of the temporary injunction petition. There is no question, howsoever, of reviving that initial order of status quo. Your lordship is deciding the decision validity of the order passed by the learned trial court and also whether injunction is to be granted or not. And there is no question of making a prayer that initially there was a status quo order, lordship will kindly restore that. And this is the prayer they are making because they know they cannot openly and clearly pray before your lordship that transmission should be prevented. That is why they say lordship will kindly grant it so that they can take advantage of that order in the way they have been taking so far. Last 13 years, they have prevented us from exercising my right and which cannot be compensated. Why I am saying, my lord, it cannot be compensated because they have from time to time, last 13 years, they have taken decisions where I was not a party and I am holding what, how much a percentage of shares? 38% shares, my lord. A person holding 38% of the shares will have a bigger say in the meetings and the decisions to be taken by the board. But I am out. How? By an order which is neither specific nor are they granted. But they have taken advantage of saying that there is a status quo order, I cannot grant you. And the Honorable Supreme Court says that my right also has to be seen. What is my right? Under the law, I am entitled to exercise all my rights as a joint shareholder because I am the surviving member of the joint shareholders. And injunction prayer also they have made is to prevent me from transferring those shares. And this transfer, as the lordship has actually pointed out, that before I transfer, there has to be first a transmission to make me owner. So that is why they say that those papers, these slips, these delivery slips which the father at that time granted for the purpose of giving him the right to transfer those shares again in her individual name should not be utilized by me. This is their prayer. Because once I utilize those papers, father was thinking that I may use it for the purpose of transferring it to a third party. Now NSDL says, the bank says, depository participant, no. Unless both of them sign, I cannot do anything. Because it's a joint hold. Now,
Was at the time when both were alive.
Yes. Both of them were. At that time, there was an apprehension. Father was apprehending that he has already signed and he.
Now, since the father is no longer there, that insistence is also no longer there.
Yeah, that is why the trial court has refused injunction.
No.
My lord.
What I am saying is that at that time, the authorities refused that unless both sign, we cannot.
Yes.
Now there is only one remaining.
Now I can.
So she can, yes.
Now I can. That's why I say, my lord, they have made a prayer that I should not transfer. I should be prevented from transferring, and I am conceding to that prayer because I do not have any intention of transferring to a third party. Let it remain till the suit is decided at the trial. But what they are now. Other shares also. And that was the order passed in respect to the mother shares also. So, my lord, what I am saying is, my lord, indirectly, which they cannot attain directly, they are indirectly asking for a relief before the Honorable Court, by virtue of which or based on which they can deprive me of my right accruing by operation of law, that is transmission, which they cannot do. My mother's suit, in that suit, what is happening, I am not relevant, I am not going to check. Just to check. On. 186 may be of some relevance to counter their submission. That I think it format was just two pages on page 180 and 186 will do it, page 186
Of the volume
of the FAO.
Sorry, yes, ma'am.
FAO.
186. This is HDFC Bank.
Yes, ma'am. DP, that is depository participant, they have written to the plaintiff when he was alive, manner. With, may I read, manner? With reference to your caption letters, we wish to inform you that as you are aware, the said demat account is maintained jointly. That is Hemendra Prasad Barua and Sharmila Vijay Shetty as first and second holder respectively. Hence, the mode of operation of the said demat account is joint, and the instructions for the said account should be signed, authorized by both the account holders. So there is no concept like first holder, second holder, first holder having bigger right, second holder having no right. There is no concept like that. It is their submission, my lord, without any material to support that submission. Then second paragraph, my lord. And my lord, the third paragraph, my lord, further, with reference to your query on new delivery instruction booklet, kindly submit the requisition only signed by both the account holder as per the mode of operation of the demat account. So my lord, when there are two joint holders, both have equal right. There is no basis for arguing that, see, you are a second holder, your right is less. You have been brought there only for the purpose of convenience of operation. And my lord, in the plaint, they have made one such submission. I have to point out, my lord. Yes, they have mentioned that it is in the name of the plaintiff and defendant was inducted, but that is not correct. The plaintiff himself had opened a joint account, my lord. Both of them, plaintiff and the defendant number 2.
Yes.
I'm making one more submission, my lord, that a averment is there in the plea that the defendant number 2 respondent, the plaintiff opened the account and defendant number 2 was subsequently inducted as a joint holder, so as to show that she is nobody. But law doesn't recognize such thing. Law says that it is different if it is joint account. Then now, what I am trying to show your lordship is that from their document, that father and the daughter jointly opened a joint account. Then further bought those shares in the joint account. So moment those shares are brought in the joint account, both the joint holder are equally entitled to the right of those shares. And that is why he had to approach the civil court, my lord. Otherwise, if the operation of law so provided that he was the first holder and the daughter was the second holder, then there was no necessity of going to court because first holder has the all right and second holder doesn't have anything. That is not correct, my lord. Lordship may just have a look at this. They are rejoined, my lord, in IA 3216 page. At page 1434 of rejoinder affidavit by the appellant in IA 3216. In the inaction application here, madam. I am referring to page 1434, madam.
Yes, what does it say?
This is for opening an account, the joint account. And at page 1435, what you will find, there is a declaration by both the holders, my lord. In the middle, after their photographs, my lord, just below their photograph, there is a declaration. Lord may mention that it's a declaration. The rules and regulations of the depository and deposit.
Yeah, you can go on. 3216.
Page 14. In IA 3216.
এখন affidavit আছে legender. Affidavit এখন আছে legender affidavit come করতে Resender affidavit to OP number 2 or 3? 3414.
3216.
Okay, 31434 page.
Yes. Page 1434. Is the application for opening an account. Of this DP deposit department. I'm referring specifically to page 1435, relevant part. Application starts from page 1434. Service got manner.
1434 is only Hemen Burwa.
Connection arts on top, manner.
Yes,
Yes.
this was referred to earlier also by.
Yes, ma'am.
We are sure.
And this is application for opening an account. Now, next page, if your lordship kindly turns to, just after the photographs of these two applicants, my lord, there is a declaration. It says that the rules and regulations of the depository.
This is a continuation.
My lord,
This is a continuation of 1434.
after the declaration, in the declaration is mentioned that the rules and regulations of the depository and depository participants pertaining to a account which are in force now have been read by me, us, and we have understood the same, and we agree to abide by and be bound by the rules as are in force from time to time for such accounts. We also declare that the particulars given by me, us, are true to the best of my knowledge, etc. And we agree that any false information given, they have agreed to follow the depository rules, and their bylaws, which says that transmission will take place on the death of one of the
First holder.
members. Now, my lord, just after this, below this declaration, this is a application made jointly by both of them for opening an account. And just below the declaration, let me find the names are there. First holder, second holder, third holder. This first holder, second holder is mentioned for the purpose of maintaining seriatim, because there may be 10 such persons who may be jointly holding, but both of them are joint holders and they have got equal right. Similarly, in a sale deed, if there are number 1, number 2, number 3, all are equal holders. Only because in serially a person's name is mentioned as serial number 3, he doesn't become a lesser owner. Well, just for the purpose of completing my submission, my lord, the judgment passed in Dalpat's case. Just 2 paragraphs may be relevant. I will not read, my lord. I am just saying that I am relying on those 2 paragraphs, my lord. Para 4 and 5. 1992 1 is to see. 1992 1 is to see page 719, Dalpat Kumar and another versus Prahlad Singh and others. Para 4 and 5. I am relying. Order 39 Rule 1C provides that temporary injunction, para 4 I am reading, madam. Order 39 Rule 1C provides that temporary injunction may be granted where in any suit it is proved by the affidavit or otherwise that the defendant threatens to dispossess the plaintiff or otherwise cause injury to the plaintiff in relation to any property in dispute in the suit. The court may by order grant a temporary injunction to restrain such act or make such other order for the purpose of staying and preventing or dispossession of the plaintiff or otherwise causing injury to the plaintiff in relation to any property in dispute in the suit as the court thinks fit until the disposal of the suit or until further orders. Pursuant to the recommendation of the law commission, this we can skip, my lord. Just 8th, 9th line from the bottom. The exercise thereof is subject to the court satisfying that there is a serious disputed question to be tried in the suit and that an act or on the facts of before the court, there is a probability of his being entitled to the relief asked for by the plaintiff defendant. The court's interference is necessary to protect the party from the species of injury. In other words, irreparable injury or damage would be ensue before the legal right would be established at trial. That the comparative hardship or mischief or inconvenience which is likely to occur from withholding the injunction will be greater than that would be likely to arise from granting it. Therefore, the burden is on the plaintiff by evidence alleged by affidavit or otherwise that there is a prima facie case in his favor which needs adjudication at the trial. The existence of prima facie case right and infraction of the enjoyment of his property or the right is a condition for the grant of temporary injunction. Prima facie case is not to be confused with the prima facie title which has to be established on the evidence of the trial. Only prima facie case is a substantial question raised bona fide which needs investigation and a decision on merits. Satisfaction that there is a prima facie case by itself is not sufficient to grant injunction. The court further has to satisfy that non-interference by the court would result in irreparable injury to the party seeking relief and that there is no other remedy available to the party except one to grant injunction and he needs protection from the consequences of apprehended injury or disposition. Irreparable injury, however, does not mean that there must be no physical possibility of repairing the injury, but means only that the injury must be of material one, namely one that can be adequately compensated by way of damages. The third condition also is that the balance of convenience must be in favor of the granting the injunction. The court, while granting or refusing to grant injunction, should exercise sound judicial discretion to find the amount of substantial mischief or injury which is likely to be caused to the parties. If the injunction is refused and compare it with that which is likely to be caused to the other side, if the injunction is granted. If on weighing the competing possibilities or possibilities of the likelihood of injury and if the court considers that the pending the suit, this subject matter should be maintained in a status quo and injunction would be issued, thus the court has to exercise its sound judicial discretion in granting or refusing the relief of ad interim injunction pending the suit. By relying on these two paragraphs, I would submit, taking support from these two principles laid down by the Honorable Court, my lord. Here is the case, my lord. Although the father has filed the suit that, see, I am the owner, but law provides that by operation of law, the transmission will take place. Now, if the apprehension of the plaintiff is that during the pendency of the suit, something may happen for which ultimately they cannot be compensated, they have to be protected. Now, what is the protection? That the status quo should be maintained. And in this sense that the learned trial court initially passed an order of status quo. But the fact remains that it is now clear that they have taken advantage of the status quo order and by abuse of the process of the court, they have deprived me of my right to the shares. That is why, my lord, I am saying that let there be a specific order. If they want to protect the interest, that is the shares should remain intact. Let there be an order restraining me from transferring those shares to a third party. But in the meantime, so far as transmission to me is concerned, which is by operation of law, that may not be granted because once that is granted, they will enjoy the benefit of the shares and whereas under the law, I am entitled to the benefit.
But by way of the earlier order passed, the shares have been transferred back to their account anyway.
Because, my lord, that is why I did not read the whole order. Honorable Justice Midul Kalija passed an order because, my lord, there was an interim order on 24th of September that order was not produced, some other order was produced, initial or some other order was produced. That was according to the court, that was a suppression of fact. Because of the suppression of fact, the court says, no, I'll reverse. Now the court will take the call whether a temporary injunction can be granted, preventing the transmission also. That order will not influence, but the Supreme Court has very clearly stated that any observation made in the impugn order will not influence this honorable court.
That is also the law otherwise. But in that case, we would again have to pass a specific order transferring the shares back to you.
Because what I'm saying is, if transmission takes place, but transfer is prevented, I cannot sell it to a third person. It will remain with me. So that if I'm a party in the suit, if ultimately decree is passed, court will say that now it will be transferred in the or transmitted in the name of the plaintiff. They will not be suffering anything. No prejudice will be caused to them.
Yes.
That is my submission.
I'll need about half an hour any day, half an hour,
Next week? Next week?
Next week, next week.
30th is next week.
Tomorrow is not possible.
Sorry,
30th, 30.
30, is it? Or 12th May, if I'm told, it's only Tuesdays and Thursdays which perhaps will take up these matters.
Hearing matters.
This 30th is a Thursday.
If it's any day, we take up the matters, then we can.
Let it be 12th minute. I was so slightly. 12th.
11th would have been perfect. I don't know whether we'll take it up on a Monday. If not, then
12th again is a minor Monday.
12th, no,
Let it be on 12th minute. It's a hearing day. Lots of in a better position too.
I've got some matters.
Yes.
Oh. So 30th April, if it is convenient to
Better if we could have concluded next week itself, otherwise things need repetition again.
Then 30th, we'll.
30th April. Because it's only your submission is
Yes,
remaining.
yes. We have the elections on the 29th so far as our state is concerned. We'll come back on.
After casting its vote in the evening flight.
Yes.
Only 30th.
Going by the situation there, it is better to come out of.
Yes.
Very hot.
That one we don't
Very
know.
hot. Very hot. As we see.
Okay, chocolate. Chocolate. Chocolate flight test. Is it my lord's pleasure, that it's fixed at any point of time? So we can
Is the morning flight.
we'll take the morning flight because 29th, there may be some difficulty in catching a flight. The elections will be there.
You can take it in the second half also. If you
Second half, 2 o'clock, then
Or 12 noon.
12 noon, 2 o'clock.
2 o'clock.
12 or 2, whatever is convenient.
Since you have said half an hour, we will accommodate you at any point of time.
Half an hour to 45 minutes. Now, I know what it entails because.
Okay, come, we'll see, we'll
Very,
work out
very,
something.
I'm grateful. Grateful. I'm grateful.
Interim order continue and order in part was.
The interim order can continue.
Stop right.
Item number 35,
Grateful.
interim order may be continued by. In item number 35.
নোট কৰি থব পাঠক হেৰি 35 ইন্টাৰিম টু কন্টিনিউ
May I please, Your Honor?
This is item 34, Lordship. The matter may be fixed on in the first week of, Lordship, May. Can it be on 5th? We both are, there we are under pressure, Lordship.
5th of May,
5th of
34.
34.
Obliged.
Obliged.
Hey, please, Your Lordship. In regards to item 37, Your Lordship, the matter is ready for hearing. Perhaps Your Lordship may take it after 2-3 weeks, as per Your Lordship's convenience.
List after 2 weeks, that data did.